So writer number 2.
May I please alert? The minor daughter of the present petitioner has been kidnapped by the opposite party number 3 and others. And the occurrence took place on 13/9 and 2023. And subsequently,
One is the minor daughter of
the present petitioner
yes
has been kidnapped by petitioner number 3 and others.
Opposite party number 3.
3 years. The affair lost on 15/9 years.
What is the age of your daughter?
17/1/2009.
16 years.
Okay. 79 is minor. So, what is your instruction, Mr.
Phrase matter.
Oh, phrase matter.
Yes.
Obtain instruction about the status of the case and whether the what attempts have been made to rescue the victim girl. Since when she is missing?
Yes, sir.
Kebbe true.
13/9.
13/9/23.
Yes, sir.
All right. This WP schedule in the nature of habeas corpus has been filed by the petitioner, Prasanna Parida alias Prasanna Kumar Parida, with a prayer requiring production of the minor daughter of the petitioner, who is allegedly kidnapped by the opposite party number 3 and others. And counsel for the petitioner submitted that in connection with such kidnapping, FIR has been lodged by the petitioner before the inspector in charge of Banki police station, and accordingly Banki PS case number 325 dated 15/9/2023 was registered under section 363/34 of the Indian Penal Code against the opposite party number 3 and others. But the daughter has not yet been rescued. That the Land Council for the state obtain instruction about the status of the case as well as attempts made by the IAC/investigating officer to rescue the victim girl and also to arrest the accused persons. Put of this matter, 20 tarika se will commencing from 20th of November 2023. So produce the case diary on that day. Yes. Yes. Free copy of the order be handed over to the Learning Council. Yes.
Item number 12.
The petitioner's minor daughter has been kidnapped by the FIR name accused person. Today is personal appearance of the IIC Rajkanika PS for submission of the status report.
Last time it was listed on 9/10/23, right?
Yes.
On that day also, no, on that day IAC was not present. He submitted only a report. Yes, the IAC is present. What is the name of the IAS? Give him a slip so that he'll write the name and designation. He's not the, is he the IAC?
IO, my lord.
Oh, IU. 83/2008 means minor. This number, serial number 8 of your status report which you have submitted today. See that. Ajiro jo status report ta ଦେଇଛନ୍ତି paragraph 8 ଟିକେ ଦେଖିଲେ ଆରେ କଣ status report ଆପଣ କପି ଆପଣ
ଧରିକି ଅଛନ୍ତି ଦିଟା ଚାରିଟା କୁଆଡକୁ ଧରିକି ଅଛନ୍ତି।
ଦିଅନ୍ତୁ ତାଙ୍କୁ ଦିଅନ୍ତୁ। ଯୋଉଟା ଲେଖିଛନ୍ତି ଯେ as per the information and sources search the accused so at Tirupati, Utkali, Erode and other probable places of the state of Andhra Pradesh to apprehend the accused as well as the rescue of the victim but found them absent. କେବେ ଯାଇଥିଲେ ଆପଣ?
ସାର୍ 25 କେସ୍ ହେଲା ପରେ ସାର୍ ଯାଇଥିଲି ଟିକେଟ କରିଥିଲି।
ମେନସନ ହେଇଛି କେସ୍ ଡାଏରୀରେ?
ଆଜ୍ଞା ସାର୍ କରିଛି।
ସେଠି ଯାଇ କଣ କଲେ? କିଏ ଯାଇଥିଲେ? ଏକୁଟି ଆପଣ?
ନାଇଁ ଆଉ ଆମ ସ୍ପେଶାଲ ସ୍କ୍ୱାଡ୍ ଯାଇଥିଲା ଜଣେ।
ହଁ
ଆମ ସ୍ପେଶାଲ ସ୍କ୍ୱାଡ୍ 2 ଜଣ ଯାଇଥିଲେ, ମୁଁ ଯାଇଥିଲି ସାର୍। କିନ୍ତୁ ସାର୍
କିଏ ଆପଣଙ୍କୁ ଖବର ଦେଲା ଯେ ସେଠି ସେମାନେ ଲୋକାଲ
ସେ ଗାଁ ଲୋକ ଅଛନ୍ତି
ମାନେ ଆକ୍ୟୁଜ୍ଡ ର ଗାଁ ଲୋକ?
ଆଜ୍ଞା।
ଆଚ୍ଛା, ସେମାନେ କେମିତି ଜାଣିଲେ?
ସାର୍ କାମ ଦାମ ପରେ ବାହାରେ ରହିକି କମ୍ପାନୀ ପହଞ୍ଚେ।
ଆଚ୍ଛା
ସାର୍ ସେଠି ଗଲାବେଳକୁ ପାଇଲି।
ନାଇଁ ଯିଏ ଆପଣଙ୍କୁ ପଛଆ କହିଲା ଯେ ତାକୁ ଆମେ ତିରୁପତିରେ ଦେଖିଥିଲୁ କି ଏଇ ଟାଇପ ର କହିଲା ନା କଣ କେମିତି?
ସାର୍ ସେ ରହିକି ସେଠି କାମ କରୁଛି ବୋଲି କହିଲା, ପଳେଇଲା ପରେ
ଆଚ୍ଛା
ସାର୍ ସେଇ ଆଧାରରେ ସାର୍ ଯାଇଥିଲି।
ହଁ ତିରୁପତି କୋଉ ଜାଗାରେ କଣ?
ସାର୍ ତାମିଲନାଡୁ ସାର୍।
ତିରୁପତିର କୋଉ ଜାଗାରେ? ତିରୁପତି
ଉତ୍କଳି ସାର୍ ଗୋଟେ କମ୍ପାନୀ। ସେଠି
କଣ ହେଲା ସେଠି? ଉତ୍କଳି କମ୍ପାନୀ ଯାଇଥିଲେ? କଣ ହେଲା ସେଠି?
ମ୍ୟାନେଜର ସହିତ କଥା ହେଲି ସାର୍, ପାଇଲି କମ୍ପାନୀ ଯାଇଥିଲି।
ସେ କାମ କରୁଥିଲେ କି ନାଇଁ?
କାମ କରୁଥିଲା ନା ନାଇଁ? ମତେ
ମନା କଲେ ସାର୍, ସିରିଏଲ ଦେଖିଲେ ମନା କଲେ, ପ୍ୟାକ୍ କଲେ।
ଫଟୋଗ୍ରାଫ ଦେଖେଇଲେ ତାକୁ?
ଆଜ୍ଞା ସାର୍।
ସେ ମନା କଲେ?
ଆଜ୍ଞା ସାର୍।
ତାମାନେ ଆପଣଙ୍କୁ ଯିଏ ଏମିତି ଟାଇପ ର ଇନଫର୍ମେସନ ଦବ ଆପଣ ପଳେଇବେ ସେଠି ଯାଇ ବୁଲିକିନା ଆସିବେ ନା?
ନାଇଁ ସାର୍, ପ୍ରୋବାବିଲି ଥିଲା ବୋଲି ଯାଇଥିଲୁ ସାର୍। ତାଙ୍କ ଗାଁ ଲୋକ କହିଲେ ସେଠି ଅଛି ବୋଲି।
ତିରୁପତି ଦର୍ଶନ କରିବାକୁ ଯାଇଥିଲେ ଯଦି ଠିକ ଅଛି।
ନାଇଁ ସାର୍,
ଆଉ
ବ୍ୟାକ୍ କରି
ଷ୍ଟେଟ ଏକ୍ସପେନ୍ସେସ୍ ରେ ଆପଣ ଯାଉଛନ୍ତି, ଅଥେଣ୍ଟିକ ଇନଫର୍ମେସନ ନ ଯାଇ ଯିଏ ଗୋଟା କହିଦବ ଯେ ଆମେ ତାକୁ ତିରୁପତିରେ ଦେଖିଥିଲୁ, ଆପଣ ପଳେଇବେ ତିରୁପତି।
ନାଇଁ ସାର୍, ଇନଫର୍ମେସନ ହେଇଥିଲା।
ପର୍ଟିକୁଲାରଲି ଯଦି ସେ ଲୋକଟା ବି ସେ କମ୍ପାନୀରେ ଚାକିରି କରୁଥିଲା ତାହେଲେ ଆପଣ कॉल करिकिनी से ये को पचार थांते जो जिनसटा आपण सेठी जाइकिनी बुझिले से जिनसटा तो एठी बुझाई पारथांता तर सेठी जाई लाभ कोन हला कोन कले हमु कोन
सब
सेठी जाइकिनी
सब सेठी जाएंगे
से कंपनी टा बुलदी पळाइले से मना कर देला मैनेजर सेठू बाहर पळाइले से जदि भी काम करथो से मना कर देइथला आपण वेरीफाई कलेनी
हाँ सर तांको रजिस्टर वेरीफाई
कोनटा रजिस्टर
तांको कंपनी जो सर कंप्यूटर जे तांको सब छोड़ी थाए ना सब
हम्म
जो पिला काम करछन
कौनटा कहती कौन कहती कौनटा देखिथे अटेंडेंस रजिस्टर देखिथे मास्टर रोल देखिथे कौन देखिथे आपण कहले सिना देखि आपण तो कहले कंप्यूटर रे जहा चढ़ी
से माने गोयांगी धारे देखेले पिला जो
ए जो उत्कली जोटा कहउचंती
आज्ञा।
उत्कली एरोड लेखा हिची एटा तिरुपति ना
तिरुपति
उत्कली एरोड
नहीं सर ये रोड को लगा जगह सर उत्कली अलग से तमिलनाडु सर
तमिलनाडु आपण कहउचंती तिरुपति आंध्र प्रदेश रे अछि तिरुपति ता तमिलनाडु रे नाही आंध्र प्रदेश रे आपण लिखिचंती भी आंध्र प्रदेश लिखरी एरोड ता अछि तमिलनाडु रे आपण कोठु गले
तमिलनाडु ठीक है
आपण लिखिदेले कोन तिरुपति पळै जिवो तमिलनाडु को
नहीं सर तिरुपति
Tirupati is in Andhra Pradesh.
सब
Erode is in Tamil Nadu. That is why I put to you this Utkali is in Erode or in Tirupati.
सब लेके गुंजाइश थी सर तमिलनाडु
election state of Andhra Pradesh election. So you verified the attendance register or the master roll, didn't find the name of that person
Nice.
there.
Sir.
So it's absolutely fake information has been given and unnecessarily officials are visited. In this way, wasting the time and not only your time but also the money, exchequer money, all these are wasted. Now, say पिलार किसी अकाउंट करिया थिला
Nice.
बैंक अकाउंट
Nice.
What is the age of that accused?
It's 13 years.
Again?
Um,
Age of the accused.
accused पचरा
Accused,
बुझिकिनी कोंतु
Again?
measures
No, major nahi कहतु. Major,
20 years.
don't try to bluff.
Nice.
Have you really seen it?
Sir.
Whether he is just major or he is 31 years. See it?
Nice sir. 20 वर्ष
20 वर्ष हबो लिखिचंती अछि देखिले
गौरव हरि स्वाई
20 वर्ष
he is working as a laborer
22 years.
सर काम किछ करनथला गारे बोलथला
हम्म
ए काम दम जाई
जियो कोन पढुथिला ना
जे सर पढुथला न
Ninth
दशम
class.
परीक्षा देता
हम्म
ओ थिला 3 मास थिला सर दशम
हम्म
3 मास कोन थिला सर दशम परीक्षा देता
तम दशम परीक्षा देइनी अच्छा so now Vartaman, what did you propose to do to trace out the victim girl and the must be feeling the anxiety of the parents, their minor daughter who is just aged about 15 years. She had gone with somebody and the accused is keeping no contact with his family members. Tell us what do you propose to do further? এই টাইপର ଚଲେଇଥିବେ ମାନେ କେସ୍ ଡାଏରୀ ମେଣ୍ଟେନ୍ କରୁଥିବେ ତାପରେ ପୁଣି ଆଉ ଗୋଟେ କୋଉଠୁ ଇନଫର୍ମେସନ ଆସିବ ଯେ ସିଏ ଗୋଆରେ ରହୁଛନ୍ତି ତାପରେ ଗୋଆ ପଳେଇବେ. How do you plan to meet it? Suppose you get the information, unless it is verified authentic information हवा ପାଇଁ ତାର ଆଉ କିଛି source ନାହିଁ. ଗୋଟେ ଯଦି ଇଏ ହେଲା ଆପଣଙ୍କର ଏସପି अप्रोच कले सेठिकार कनसर्न एसपी को सी रिक्वेस्ट करिकिनी से जिनस असर्टेन करि परिबनी जदी आपण किछि कंक्रीट इंफॉर्मेशन पाइले आपण जिवे नले एम तो गोटे पर गोटे इंफॉर्मेशन आसीबो चल जिवे ना
सब मजुरी इंफॉर्मेशन पाइले हैदराबाद ପ୍ରପର କଂକ୍ରିଟ ଇନଫର୍ମେସନ ପାଇଲିନି ବୋଲି ଗଲିନି ସାର୍। ମାଗିଥିଲି କିନ୍ତୁ ତାର ପର୍ଟିକୁଲାର ନମ୍ବର ସବୁ ଭେରିଫାଇ କିଛି କରିନି। ଚେଷ୍ଟା ଚଲେଇ ସାର୍ ତାଙ୍କ ଗାଁରେ ଯାତ୍ରା ଚାଲିଛି, ବାହାର ପିଲା କିଛି ଆସିଛନ୍ତି ସାର୍, କାଲିଠୁ ଆରମ୍ଭ ହେଇଛି ଯାତ୍ରା। ସେ ଗାଁରେ ସାର୍ କାଲିଠୁ ଆରମ୍ଭ ହେଇଛି ଯାତ୍ରା, ବାହାରେ ଯୋଉ ପିଲା ସାର୍ ପାଣି ପାଇପ ରେ କାମ କରୁଛନ୍ତି ସେମାନେ ପିଲା କିଛି ଆସିଛନ୍ତି। ତେଣୁ ସାର୍ କାଲି ରାତିରେ ବି ଯାଇଥିଲି ଏଇ ଇନଫର୍ମେସନ କଲେକ୍ସନ କରିବା ପାଇଁ। ଆଜି ସାର୍ ଯିବି ସାର୍ ଟାଇମ୍।
ପିଲାମାନଙ୍କୁ ପଚାରିଲେ ଯଦି ସେମାନେ କେହି କହିପାରିବେ, ଯଦି
ଆଜ୍ଞା
ତାଙ୍କ ପାଖରେ ଯାଇ ଥିବ, ଯଦି ସେଠି ରହୁଥିବ କି ସେ ଲୋକାଲ
ରହୁଥିଲା ସାର୍, ମଝିରେ ସେଠୁ ପଳେଇ ଆସିକି ସାର୍ ଯାଇଥିଲା ସାର୍, ଆସିକି ହାଇଦ୍ରାବାଦରେ କରୁଥିଲା ବୋଲି କନଫର୍ମ ହେଇପାରୁନି ବୋଲି ସାର୍ ଯାଇପାରୁନି। ତେଣୁ ସାର୍
ନାଇଁ, ସେ ପିଲାଙ୍କୁ ପଚାରନ୍ତୁ କେବେ ଦେଖିଥିଲେ, ତାଙ୍କୁ କଣ କାମ କରୁଛି ସବୁ କରିକିନି ଆପଣ ଆସର୍ଟେନ କରନ୍ତୁ। ତିରୁପୁର give the name, so and so the ASI of Rajkanika Police Station, who is the investigating officer of Rajkanika PS case number 170 of 2023, is present as per the order dated 9/10/2023, and he has produced the status report of the case, which is taken on record. He seeks some further time to take steps for rescue of the victim girl and also arrest the accused. This matter to be commencing from 4th of December 2023. The investigating officer shall remain present on that day and apprise this court about the development made in the meantime. Free copy of the order be handed over to the Land Council for the state for compliance. 4 तारिख रे रखिलु डिसेंबर रे, आपण या भितरे पाखापाखि मासे समय पाउछंती। आपण कोन करूच करले आ भितरे स्टेप बाय स्टेप केस डायरी मेंशन करिवे, जुआडे जुआडे गले बा जहा सर्च करले जहा करले तार डॉक्यूमेंटरी एविडेंस मध्ये हमकु आनी कि विथ द केस डायरी वर टू रिमेन प्रेजेंट ऑन दैट डे विथ द स्टेटस रिपोर्ट। हला
Item number 15.
From 15, my lord, yesterday I have filed a note which I am going to rely. That copy was solved with my learned friend. What is the case? Case is, my lord, here I am assailing my detention. And fact is, my lord, I was convicted. Again. ଗୋଟେ କପି ଦେଇଥିଲେ? ଦିଟା କପି ଦେଇଛି। Assailing here, and the case is that, my lord, I was convicted for 10 years for involving offense under section 376, and however, during pendency of the appeal, my lord, due to COVID, I was enlarged on bail. Thereafter, my conviction was reduced to 6 years. This honorable court has observed that my conviction was reduced to 6 years. And there again, after, my lord, completion of 6 years, they took me to custody on the ground that I have to spend that parole period because
that period is not to be included in as custody. And Honorable Apex Court also goes against me. But my case is a bit different. Your Lordship may kindly come to my note, Milord. That I understand, Milord, the judgment of Apex Court is repeated judgments. I have given one, and one my learned friend has also filed another judgment. Both the judgments said that the said period is not to be included as a period of custody. But your Lordship may kindly come to my note, Milord. Issues, Milord, what I have raised. Whether the period of special parole can be computed as period of custody in view of the observations made in page 26 of the judgment of this Honorable Court in criminal appeal number such and such. Moreover, when state has not moved any application to set aside the aforesaid finding. Why, Lord, what is the finding? Your Lordship may kindly come to judgment of this Honorable Court in appeal. Apparently, that was a mistake on part of the appellant and part of the state. The fact was not brought to the notice of the court. Page 26, second paragraph. May repeat something. Your Lordship is getting it. Page 26, second paragraph. It appears that the appellant Durga Prasad Jena was taken into judicial custody in connection with this case on such and such date, and he was directed to be released on bail on 23/5/17. And after pronouncement of the judgment of the learned trial court, he was again taken into judicial custody on 30/1/2018, and since then he is in judicial custody. As such, he has remained in judicial custody for more than 6 years. My contention is, my lord, that this fact was not brought to notice of this, your lordship, and this judgment was passed. Rightly or wrongly, this 6 years, inclusive of that period of parole, has been taken as period of custody. Now, what they should have done, my lord, they should have filed a petition under section 362 because it's a mathematical error, my lord, which could have been corrected. And thereafter, they should have taken me in custody. And without challenging the said finding, taking me into custody is illegal. This is my, my lord, contention, subject to your lordship's approval, my lord. Unless that finding goes, rightly or wrongly, a competent court has declared this period to be a period of custody. And once it has been decided and declared as a period of custody,
because that was not brought to the notice of this, whatever you that has been stated.
again,
This first one is correct. That 11/10/2015 you are taken into judicial custody.
my lord, my lord. Actually, it a petition appellant counsel
That is correct. As per your note, that is correct. Then the second one is released on bail 23/5. That is also correct.
again.
Then the date of judgment was and taken into custody 31/2018 is correct.
Again.
But the at least the perhaps this criminal appeal record didn't show that you have been ever released on bail as per the order of this court, right?
Again.
You have been granted parole
Again.
during that COVID period.
Again.
That was not brought to
the notice of the court.
So this court said that if you are in judicial custody, so remain
Exactly,
in
my
custody, so on so.
That-
So yes.
That
The
was-
fact remains, my lord, he has been on parole. How can that be?
yes,
overlooked?
I am in parole. But unless until you modify, you make an application to modify this observation, because this rightly or wrongly observation was there that this period is period of custody.
Well, in
No,
that way, the onus lies with both the appellant as well as the.
Now, why should I?
Another,
because-
but just see that another observation has been made in the last paragraph
Yes.
of that very
Set up.
page.
Yes.
So set up.
Set up.
So that
That's a matter
covers
of
your
calculation,
case. So
yes.
that is a matter of calculation.
Exactly.
Same page towards the last.
Last paragraph. Yes.
428 is
mentioned.
there. Huh?
Milord,
So whatever he must have.
entire contention is, Milord, this honorable court has observed
Yes.
it was a mistake on part of the counsel for the appellant and the state counsel, because this fact should have been brought to notice of the court, and that was not brought. So this observation was made.
It's a technical error, my lord.
Unless until that observation is there, my contention is subject to approval of your lordship, my lord, because honorable apex court has categorically decided that this period is not to be included as period of parole. But I am not on that.
No, it was this court.
I understand, my lord.
The court just verified the court record and that it found that he has never been released on bail.
That
is
should have
why-
been brought to the notice of the court, my lord.
No,
Like,
it
that
is
was
the
not
duty
there
of
at
either
that time.
you or your
Pardon me.
the state council.
Hmm.
If nobody has brought to the notice of the court
Again.
that during the COVID period the appellant was released on parole, okay,
Again.
and the court find that at least no bail has been granted.
Again.
That is why this observation was made. But all the same, in one of the paragraphs that has been mentioned clearly that the period of detention already undergone by the appellants, it's not a particular person, but the appellants, it
Two
also
appellants.
covers you.
Again.
Either during trial or pendency of the appeal shall be set up in
That
terms
is very
of.
clear, yes, my lord.
So, what is the you have to suffer the rest part of the.
I filed
I don't
a
dispute
counter
that.
affidavit, my lord,
Yes.
where I've given the period of custody.
What is that?
My lord, that is in the counter, my lord, I've given it. Annexure E/4 at
But-
page.
Annexed custody certificate.
Yeah. Page 30 to 32.
Total period केते ହେଇଛି ଆପଣଙ୍କର? 5 years.
5 years, 1 month, 9 days as on June 2023 day.
So now June ମାନେ ବର୍ତ୍ତମାନ
July.
ଆଉ
August,
4
September.
ମାସ ହେଇଗଲାଣି. ଜୁଲାଇ ଅଗଷ୍ଟ ସେପ୍ଟେମ୍ବର
So,
ଅକ୍ଟୋବର 4 ମାସ ହେଇଗଲାଣି. ତ
5
5
years.
ବର୍ଷ 5 ମାସ.
6 months, 9 days.
ହଁ.
And 420 is the duty of
This
the jail authority.
writ petition has been filed by the petitioner Durga Prasad Jana for issuance of writ in the nature of habeas corpus for passing appropriate order oblique direction for immediate release of the petitioner from illegal confinement by declaring the period of special parole to be treated as period of custody. It is the case of the petitioner that in connection with Bhograi PS case number 144 dated 8/10/2015, registered under section 376 bracket 2 bracket D bracket I oblique 323 oblique 109 of the Indian Penal Code and section 4 of the POCSO Act. The petitioner was taken into judicial custody on 11/10/2015 and he was directed to be released on bail on 23/5/2015. The London Trial Court, that is Additional Session Judge cum Special Judge Balasore, in special case number 245 of 2015, charged the appellant under section 376(2)(d)(i) and 506 of the Indian Penal Code and section 4 of the POCSO Act. And sentenced him to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 5,000 in default to undergo further rigorous imprisonment for a period of 3 months for the offense under section 506 IPC, rigorous imprisonment for 10 years and to pay a fine of rupees 10,000 in default to undergo further rigorous imprisonment for 6 months for the offense under section 376(2)(d)(i) and in view of section 42 of the POCSO And at the time of pronouncement of the judgment by this court in CRL number 105 of 2018 on 12/10/2022, the said fact was not brought to the notice of this court. However, since this court has already observed that the petitioner has remained in judicial custody for more than 6 years. And the state has not filed any application for correction of that portion of the order. The appellant, the petitioner, cannot be taken into custody even though he has not remained in custody for the period sentenced by this court in the criminal appeal, as per the judgment of the passed in the criminal appeal. The current counsel submitted that the petitioner was taken into judicial custody on 31/3/2023 in spite of the observation of this court in the judgment passed in the criminal appeal filed by the petitioner, and therefore the same is illegal, and the petitioner should be immediately released from illegal confinement by declaring that the period of special parole to be treated as period of custody. ये जो special parole on account of COVID कर देंगे. The Ms. Sashwat Patnaik, an additional government advocate, on the other hand, submitted that while adjudicating the criminal appeal, it was not brought to the notice of this court by either side that the petitioner has been released on special parole on 2/6/2021, and this court, after going through the appeal records, found that since the petitioner has not been released on bail by the appellate court, made the observation that he has remained in custody for more than 6 years. In fact, the petitioner had not remained by then in judicial custody for more than 6 years. However, since the observation of this court is very clear in the subsequent paragraph that the period of detention already undergone by the petitioner, either during trial or pendency of the appeal, shall be set off against the term of imprisonment as imposed under 428 of CRPC, and the petitioner has not undergone 6 years of substantive sentence as imposed by this court in the criminal appeal. Rightly, he was taken into judicial custody again on 31/3/2023 to serve out the remaining part of the sentence, and there is no, it cannot be said that he was illegally detained or put under confinement, illegal confinement, and therefore no relief can be granted to the petitioner. And counsel for the state relied upon the decision of the Honorable Supreme Court. You Rohan Dhungar, huh?
ଦିଟା ଦେଇଛନ୍ତି ଅବତାର ସିଂ
ରୋହନ ଦୁଙ୍ଗଟା ମୁଁ ଫାଇଲ କରିଥିଲି ସେ ଫାଇଲ କରିଥିଲେ ଆର
ଆପଣଙ୍କ decision ଗୁଡା କୁଆଡେ ଗଲା?
ସେଗୁଡା ଦେଇଛି ମୁଁ
ଏଇ ଦେଲେ
ଗୋଟେ ତ ଅନିଲ
ସେ
କୁମାର
ଦେଇଛନ୍ତି ଏଥିରେ
versus
କାଉଣ୍ଟରରେ ଦେଇଛି
କାଉଣ୍ଟରରେ
କାଉଣ୍ଟରଟା କାହିଁ? ଆରେ ଏଠି ବାହାର କର କାଉଣ୍ଟର।
page 19 page 19 of the counter ମୁଁ ଜଜମେଣ୍ଟ ଟା ମୋ ନୋଟ ରେ ଦେଇଛି
ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍, ମାନେ କରୁନାହାନ୍ତି କିଛି ନାହିଁ, ମାନେ ଅପଡେଟ କିଛି ନାହିଁ।
ଏଇଟା ଅଛି
ଅଛି
page 50.
page 19
Page 19.
annexure D by 4
That is it. 50.
The Land and Council for the State, କେତେ ନମ୍ବର ପେଜ ରେ ସେଟା ଅଛି?
19
page 19
ପେଜ
19
19.
next D by 4
wait ଗୋଟେ ପେଜ ରେ 4ଟା 5ଟା ନମ୍ବର ଦିଆହେଇଛି ଆଉ କଣ କରାଯିବ? 19 ମାନେ D/4 ଯୋଉଟା ଲେଖିଛନ୍ତି।
D by 4 Anil Kumar
All right. Place the reliance on the case of Anil Kumar versus State of Haryana. It is the report देखिए. Wherein it was held को paragraph टा कुहंतु. आउ को डिसीजन रिलाय करछनी तापर एकाथरे लिखि देबा तो. ए गोटे डिसीजन तो
ଆଜ୍ଞା
same principle is there here in this Rohan.
ରୋହନ ନେ ସ୍ପେସିଫିକ କରି ଦେଇଛନ୍ତି ରିଜନ ଟା
ଓଭରଟା ସେମାନେ ପ୍ରିମେଚର ରିଲିଜ ପାଇଁ ଡିସାଇଡ କରିଥିଲେ
Oh,
but the principle is the same
that period cannot be taken.
the period
ସେ
of time
ପାରା
can be
10 ଟା
counted
ହଉଛି
as
ରୋହନ ର ଜଜ
So also in case of Rohan Dhungar versus State of Orissa.
ଗୋଆ
ନାଇଁ,
state of
state of
Goa
Goa and other.
ମାନେ
State
ଲାଷ୍ଟ
of
ପେଜ
Goa and others.
page 27 ରେ ଅଛି 5.1 5.2 and 5 and 6
Reported in AR 2023 Supreme Court 265. Acha, in case of Anil Kumar bracket re Supra, the Honorable Court, the co paragraph टा कुहंतु.
page 5 a paragraph 5 page 26 ସେ ତିନିଟା କ ପାରା ଲାଷ୍ଟ ସମଅପ୍ କରିଛି
Just a minute.
para 5 5.1 5.2 and 6
5.2 ରେ ରୋହନ ଡୁଙ୍ଗର
ଆଜିର ବି ଧୁନଗଡ଼
Rely.
ସେଇ କେସ୍ ଟାକୁ ମଧ୍ୟ ରିଲାଏ କରୁଛି।
ଆଜ୍ଞା ଆଜ୍ଞା
କରିକିନି ଅଲ୍ଟିମେଟଲି କଣ କରିଛନ୍ତି? Similar in with the petitioner has been convicted so and so he has to undergo said actual subject to the policy on the period during which he was released on emergency and emergency has to be excluded.
Where of the family that but is supposed to be still in prison. Of that.
ଏଇଟା ଅନ୍ୟ
Of that, that is.
अच्छा ये paragraph 6 का कोट कर देवे है ना, ये held as follows. And in case of जो Rohan Dhungar, the Honorable Supreme Court has held as follows. Quote paragraph number 10. Therefore, in view of the settled position of the law, the special parole period which was granted in favor of the petitioner on account of COVID cannot be taken into account for determining the period of custody.
the actual period of imprisonment
Actual period of imprisonment. There is no dispute that the said fact was not brought to the notice of this court while adjudicating the criminal appeal, and and since this court has already passed the made the observation, further observation in the while rendering judgment in the criminal appeal that the petition period of detention already undergone by the appellant either during trial and pendency of the trial, shall be set off against the terms of imprisonment as imposed section 428 of the CRPC. And since the petitioner had not undergone the substantive sentence of 6 years as imposed by the Lenin by this court after modifying the order of the Lenin trial court, rightly the petitioner was taken into judicial custody on 31/3/2023 to serve out the remaining part of the sentence. Accordingly, the contention of the Lenin Council for the petitioner that there has been illegal confinement of the petitioner is not acceptable in view of the state of affairs. We find no merit in this writ petition, which is accordingly dismissed.
Grateful.
Yeah.
Item 16.
Yes. Mr. Pramod Kumar Jena. Why it was kept to today, Mr.
Yesterday he was not
Ram?
present. That's right.
Okay. So what was our last order? 5/7/23 or thereafter any order was passed?
11/9/20.
Acha. 11/9. Habeas corpus filed by the petitioner Monalisa Padi seeking direction to the on-constant jurisdiction during course of Simudia case number so and so was registered. The written report, the petitioner spy was engaged in the locality was certain that case so and so and the victim were residing somewhere in the state of Tamil Nadu. However, the victim and the accused were not in contact with their family members or mobile notificating the location of the victim, and the accused team of police was sent to rescue the victim. All possible steps were taken to rescue the victim. Submitted that he has received instruction till date the victim has not been rescued. However, he seeks some further time to obtain. On what development has been made, Mr. Das? Yeah, the case was last listed on 11/9/2023. It's almost 2 months is going to be lapsed. So what development has been made in the meantime? Who is present today? Ayo. Who is done now designation on it? Learned counsel for the state has filed an affidavit of so and so, wherein paragraph is stated that the victim and the accused are residing so and so.
Already rescued, man.
Rescue.
Rescued, man.
Oh, other non appears for the petitioner so and so designation the diun. You sleep le likhi the diun sir. Na election di. Police station likhna hai. এই জোটা আজি ଦେଇଛନ୍ତି এটা 20/9/2023 ର ପରା within 15 days the team will proceed to rescue the victim as well as apprehend the involved accused. Will close the case but subject to file
I'll submit, man.
ଆଜ୍ଞା କନସିକ୍ୱେନ୍ସ ଅଛି
କାହାକୁ ହ୍ୟାଣ୍ଡ ଓଭର କଲେ
ସାର୍ ଦ ଫ୍ୟାମିଲି ସାର୍
ଦେଲେନି କାହିଁ ଲେଖିକିନି ଆଜି କଣ ପାଇଁ ଆସିଛନ୍ତି ତାହେଲେ ଯଦି ଝିଅ ରେସ୍କ୍ୟୁ ହେଇଗଲାଣି ତାକୁ ତା ଫ୍ୟାମିଲିକୁ ଦେଇ ସାରିଲେଣି ତା ବାପା ମାଙ୍କୁ ସେଟା ସେ ଗୋଟେ ରିପୋର୍ଟ ଦେଲେନି ଆଜି କେସ୍ କ୍ଲୋଜ ହବ ରିପୋର୍ଟଟା ପ୍ରସ୍ତୁତ କରି ଆମେ ଲେଖି ଦଉଛୁ ଆପଣ ରିପୋର୍ଟ
Subsequent to this affidavit, affidavit was there on 21st May.
produced a
हाँ,
report status report dated 29/2023 wherein it is mentioned that within 15 days the team will proceed to rescue the victim girl as well as to apprehend the involved accused. However, another status report dated so and so is filed wherein it is mentioned that the victim has already been rescued and handed over to the family members. SI Lekidebe, SI Kishore Chandra Behra, Simria Police Station, Balasore is present. The status report are taken, status reports are taken on record. The writ petition, no further order is required to be passed. Accordingly, the writ petition WPCRL is disposed of. With a new say out a report that the Adhikar body against the victim rescue available. That was Samil Kore.
Item 17.
Item 17 madam I pray for netting.
So, what is your instruction, Mr. Das?
Yesterday, the opposite party was present. Petitioner counsel was not present. They are telling, submitting that regarding the parents and that.
That mediation. So, what is the development of mediation?
Mediation failed, my lord.
Okay.
Due to hindrance of the opposite partner 1 and 2, father-in-law and the mother-in-law. And the most probably the mother-in-law is taking the hindrances, my lord.
No, whatever it may
So,
be.
and in the meantime, my lord, I have already filed an affidavit today. So, some documents that should be kept on records for the appreciation of this court, my lord. So, your worship may taken up next week so that and call for the affidavit, my lord.
You filed the affidavit today before the registry. Have you given the copy?
I'm shopping copy today in course of that day.
You are for the?
I'm the petitioner, my lord.
Okay. Land counsel for the petitioner is present. None appears for the opposite party. Number 1 to 3. Land counsel for the state is present. Land counsel for the petitioner submitted that the mediation has failed and he has filed the
Medicine
report.
report
Of that
of the
report dated sworn of the mediator is available on record. The land counsel for the petitioner submitted that today he has filed before some affidavit along with some documents before the registry, and he will serve the copy of the same on the land and counsel for the state.
I'm serving my lord's copy.
Okay, serve the copy sworn. And he further submits that he will also serve the copy on the land counsel for the opposite parties number 1, 2, 3. Okay, during course of this week, and place for an adjournment list this matter. Let them go through it. Little list.com on 20th of November 2020.
God bless you.
Item 18.
I will please your lordship.
Yes.
Petitioner's minor daughter has been cleared, which aged about 15 years, 11 months at the time of kidnap matter.
Just a minute. Land counsel for the state has produced the status report of the last order is 14/9/23 or thereafter in your in the district of Nayagarh regarding steps taken by the IO to trace out the victim and to arrest the accused person. Land counsel for the state submitted that he may be given some time to produce the case diary. An instruction from the IO as to whether there are corresponding documents to substantiate the stand taken in the status report about the steps to be okay. Which it is mentioned in connection with the case registered as the instance of so-and-so. Chandpur PS case number was registered against one Devasis Naik in connection with that FIR so-and-so. File anticipatory bail application, the main accused has filed so-and-so. Committed will verify the record of those two cases to know the stand of the accused person. Apply this court order. Yes, कौन हला आपन लिखले? These cases are pending or disposed of. APL APL 7841, which was filed by one Pratap Kesari alias Bulu Champati, and main accused has filed 482 CRPC application, that is CRLMC 2874 of 2023. Whether it has listed?
അങ്ങനെ ഗൊട്ടേരെ ABL पर ଗୋଟେ order ହେଇଛି
Order copy टा बाहर करेनी? The Pratap Kesari के पुआ क्यों से केस रो?
ମାମୁଁ ପୁଅର accused main accused ମାମୁଁ
Main accused थला देवाशीष सिंह.
ବାଲା।
ଶୁଣନ୍ତୁ ତାପରେ ବାକି ରହିଲା CRLMC କଣ ଲିଷ୍ଟ ହେଇଛି ନା ନାହିଁ? CRLMC ଟା ଟିକେ ଦେଖିଦେଲ।
2874.
Give that copy here and ଆଉ ଗୋଟେ ମାର୍କ କର ସେ ଯୋଉ ଆରଟା CRLMC 2874 of 23. See whether it has been listed or not, and if so, what order has been passed. CRLMC 2874 2023.
That is my lord 7 उठला
7 7 7 7
7 और CRLMC का
खाली this matter is taken up through hybrid mode. This is matter after 1 week. रहे क्या उठे नहीं?
देखियो गोटे ऑर्डर मात्र अछि
आज्ञा 7 रे
अच्छा तो आसीनी किसी का तो ये सरा कौन हां ये जो एबी रे
स्टाटस रिपोर्ट उठला से पुणा माने ता परे देखला 16/10 रे
एटा आज एटा आपनकर केबे गार 16/10
रो
व्हाट यू हैव रिटन
ये पाइनांति तक टेप नेशन दी डिफरेंट जगह रे भी रेड क्वेश्चन करी
parents of the victim shall be compelled to accept the marriage after being induced by the minor left in the council. Investigation revealed that accused and victim were in love. The action mobile number accused seduced and induced for marriage. Their love relation. केते वर्ष हेलानी तब जियो
time of occurrence मेरा 15 years 11 months and 17 days
ये केबे occurrence केबे इतना
डेट ऑफ बर्थ ला
19 June 2023
एक के साथ केबे को जनी
2007
एक साथ
2007 ही नथी एटलिस्ट 25 जुलाई पर्यंत रहउची so despite all sincere collected the mobile number stress CDR analysis source development technology bank transactions so on so cannot be traced further news she shall be rescued very soon election IO collected so on
next week and the presence of the IAC and
okay who has given that this yes IIC given so he has written he was confident that he will be rescued very soon soon माने ये report रू 15 दिन तो already pass कर silent okay if you want next week let it come next week the verified the order passed in case of the co-accused Pratap Kesari Champati versus State of Orissa. Order dated legi jantu 10/10/2023 in passed in ABL APL number 7841 of 2023. in which it was directed that no coercive action shall be taken against the said co-accused. However, on verification of the order dated se jo CRLMC order ta ke beitla 7/7/2023 passed in CRLMC number 2874 of 2023 filed by the main accused Devashish Singh. It appeared that the case was simply adjourned by this court. The Learned Counsel for the state has produced the status report of the IIC Chandapur police station dated 16/10/2023, from which it reveals that despite all sincere attempts, that is collection of mobile number of the accused, relatives, friends, as well as the victim, and fresh CDR analysis, source deployment, technology analysis, bank transaction verification, the victim could not be traced, and new spies have been engaged, and it is further mentioned that the victim would be rescued very soon. The Land Council for the state submitted that since more than 15 days have already passed since the date of preparation of the status report, the matter may be taken up next week, that IIC shall remain present, IIC Chandpur police station shall remain present on that day to apprise this court about the development made in the case for rescue of the victim girl. I spread for list this matter on 13th November 2023. Free copy of the order be handed over to the Learned Counsel for the state. Ranyan.
Item number 23.
23, Mr. Pramod Kumar Jena.
Rescued, madam.
Rescued. The report achi?
Yes.
The Land Council, non-appears for the petitioner, Land Council for the state has produced the report of the Filmara. The victim girl has been rescued on 1/11/2023, and statements have been recorded. And she is now accommodated in Nari Shanga, Baleshwar, as per the order of CWC Baleshwar. Hey, se mana kala घर को जीवा को आयो अच्छा ए कौन मना कला घर को जीवा को माइक रे कौन
सर झीवर बापा माँ तर अलगा रहउचंती तांकर भी डिस्प्यूट हेकरी केस चलची जे
बापा माँ भितरे
सर
ये
झीवटा ता मामू घरे रहित
मामू घर रोता
तार आई होची कंप्लेंट किंतु झीव स्ट्रिक्टली मना कले तांको आई संगरे जीवन सर
बापा की माँ पाखरे पचारलेन
तांको सर सीडब्ल्यूसी को हमें करछु तांको बापा आसिकी देखा करि जाइचंती
नो झियो झियो सिना ता आई घर को जीवा को मना कला बापा की माँ पाख को जीवा कोन मना कर देला
बापा पाखु जीव बोले कहउची हमें जोगाजोग करछु सर तांको बापा संगरे
in view of such report furnished by the status report furnished by the you are the IIC the investigating officer sworn to the present very lekhun na lekhun to designation pu thana lekhun present and report furnished by the IIC. No further order is required to be passed in this WPCRL, which is accordingly disposed of. Our designation by it elected. Non-appeals for the petitioner. Yes. Personal appearance dispensary.
Item number 29.
Lord, kind permission. Here this sole appellant before Lordship.
Just a minute. You have filed a written note of argument
Yes,
today?
Lord, for your convenience purpose, I have filed
Copy ଦେଇଛନ୍ତି?
copy ଦେଇଛି ଆଜ୍ଞା. Also,
Why are you not putting the seal? Yes.
before my Lord, I will take you Lordship the FIR page 23 and relevant page my Lord 25. माननीय श्रीयुक्त ब्राह्मणी तरंग थाना भारप्राप्त अधिकारी वेदव्यास महाशय मु श्रीराम नाथ टप्पो पिता सुअंशु बयस 39 years.
This PW5, the informant, right?
My Lord. this is the ଜଣେଇବାର ହେଇକି ଆମ୍ଭ ଘର ପାଖ ଜିତୁ ଲୋହାର ପିତା ଡମାନ ଲୋହାରଙ୍କର ଘର ଭଡାରେ ରହୁଥିବା ମୋହନ ସାହୁ ଦି ଆପେଲାଣ୍ଟ ତାର ସ୍ତ୍ରୀ ମିନି ସାହୁ ଡିସିଜ୍ଡ ମିଲର୍ଡ
Yes.
ଏବଂ ତାର ଛୁଆ ପିଲା ସହିତ ଗତ 2 ମାସ ହେବ ରହି ଆସୁଥିଲେ। ଆଜି ତା 22/10/2006 ଦିବା 12:30 ହଲ୍ଲା ଗୁଲା ଶୁଣି ମୁଁ ଦୌଡ଼ି ଆସି ମୋହନ ଘରେ ଦେଖିଲି ଯେ ତା ସ୍ତ୍ରୀ ତଳେ ଏକ କମ୍ବଳ ଘୋଡ଼ାଇ ହୋଇ ପଡ଼ିଥିଲା। ମୋହନ ମଧ୍ୟ ସେଠାରେ ଉପସ୍ଥିତ ଥିଲା ଏବଂ ଆମ ଗ୍ରାମର ଅନେକ ଲୋକ ମଧ୍ୟ ଉପସ୍ଥିତ ଥିଲେ। ମୁଁ ଏବଂ ଗୁଡୁ, ଭୀମ, ରାଜେଶ, ପ୍ରେମ ଏବଂ ଅନ୍ୟମାନେ ନେକ୍ସଟ ପେଜ ମିଲର୍ଡ ପଚାରିବାରୁ ତା ସ୍ତ୍ରୀ ଆମ୍ଭମାନଙ୍କୁ ବୃଦ୍ଧ ସ୍ୱରରେ କହିଲା ଯେ ମୋର ସ୍ୱାମୀ ମୋହନ ମୋତେ କିରାସିନ ଢାଳି ଜଳି ଜୀବନରେ ମାରିଦେବା ପାଇଁ ଉଦ୍ୟମ କରିଥିଲା। ଆମେ ଦେଖିଲୁ ଯେ ତାର ଶରୀରର ଛାତି, ମୁହଁ ଏବଂ 2 ହାତ ଜଳି ଚମଡ଼ା ଉପୁଡ଼ି ଯାଇଛି। ପ୍ରକାଶ ଥକି ଗତକାଲି ଦିନ 3ଟା ବେଳେ ମୋହନ ତା ସ୍ତ୍ରୀ ଝଗଡ଼ା ହେଉଥିଲେ। Accordingly, the FIR was lodged. The case is only raised on my lord can recollect it was once was heard by my lord. The case is based on dying declaration and circumstantial evidence. Then I will take you to Lordship. Lord, kindly see the charges, page 29.
No, the deceased died on 30/10/2006.
30/10
as
after 8
mentioned
days.
in your date chart. Right?
Yes, after 8 days of the my lord.
Okay, that is in Ispad General Hospital,
Yes.
Raurkela,
My lord.
while undergoing treatment after 8
My
days of the occurrence.
Yes. If
Yes.
lords, may I permit to place the date chart come submission?
No, you argue you on
My
your
lord,
own
yes.
way. There is no
Lord,
problem.
kindly see the charge, page 29.
Yes.
Charges, my lord. That you had on about 22nd October 2006 at about 12:30 p.m. a Sunday at about Ruguditola under Brahmantarang police station did commit murder of intentionally causing the death of your wife Minisau by pouring kerosene. Further, kindly see next page, the 313 statement, where my lord I want to appraise your lordship that relevant page 31. Question number 3. Further, all the prosecution witnesses have deposed that on the day of occurrence, you were present in the house
where the deceased sustained burn injury. What do you say? ମୁଁ ବଜାରକୁ ଆସି ଦେଖିଲି ସେ ଜଳୁଛି, ମୁଁ ତାକୁ କମଳ ଘୋଡ଼େଇ ନିଆଁ ଲିଭାଇବା ପାଇଁ ଚେଷ୍ଟା କରିଥିଲି। Thereafter, my lord, kindly see the relevant page 33. Also the accused says ଘଟଣା ଦିନ ମୁଁ ନଥିଲି, ମାର୍କେଟରୁ ଫେରିବା ପରେ ଦେଖିଲି ମୋ ସ୍ତ୍ରୀ ଦେହରେ ନିଆଁ ଲାଗିଛି, ସେ କିପରି ପୋଡ଼ିଗଲା ମୋତେ ଜଣା ନାହିଁ। These are the question of 15, my lord. My lord, here the I will take you to lordship, my lord, my note. Kindly see. I will place this note. Thereafter, I will take you evidence depositions in course of my submission. But 22nd October 2006, the occurrence took place at 11:30 p.m. and FIR was lodged before Brahmani Tarang police station, and a case under section 307 IPC was initially registered, which was subsequently turned to a section 302 IPC. Then, 22nd October 2006, 161 recorded statement was recorded. Even also the victim statement was also recorded. 30th of October 2006, the deceased died in the Ispat General Hospital, Rautla, while undergoing treatment after 8 days of the occurrence. Next page. 24/10/2006, appellant was arrested. 24 October 2006, the IO seized the wearing apparels of the appellant and forwarded him to court. 29th November 2007, the judgment was passed by the London District and Session Judge, First Track Court, Rautla, convicting the accused for rape or life. But prosecution witnesses here, my lord, there are 15 witnesses where, my lord, the PW 7, 8, 9, 11, 12, who are, my lord, the co-villagers, and they have turned hostile. And PW 2, my lord, is the forensic, wrongly, my lord, it has mentioned, it's a forensic officer. PW 4, my lord, Ranjan Sadwal, he, my lord, has conducted the postmortem. And PW 5 is the Ramanath Topo informant, my lord, neighbor of the appellant. PW 9 is the Jitu Lohar, owner house where, my lord, the appellant and the wife, deceased wife, was, my lord, staying. PW 3, my lord, Mahendra Tiwari, the person who took the deceased to hospital. All are the independent witness. And PW 4, J.K. Pagal, the IO, who visited the spot. PW 15, my lord, also Brahmani Tangar, IAC. Next page, my lord. 3. That is humbly submitted that.
Before going to your submission, tell us that what are the evidence against you?
My lord. Kindly see.
One is oral dying declaration.
My lord. My lord, the oral dying declaration.
आगे कुहंतु आगे तापर आपण सबमिशन करिबो. ओरल डाइंग डिक्लेरेशन होजी गोटे. सेटा बिफोर हुम
जितु मकार.
Before, my lord, the IO police also.
माने एफआईआर अछि.
नाने जितु लोहार को कहला पे
जितु लोहार कहछि इन्फॉर्मेंट.
कुहंतु आपण कोन अछि टागे कुहंतु तापर आपण प्रत्येक एस्पेक्ट ऊपर आपण आर्गुमेंट करिवे. आगे हमें जानू जे कोन कोन मटेरियल अछि. नो डायरेक्ट एविडेंस, राइट? ओके. So, one is the oral dying declaration before the IO is PW?
Blood PW 14.
Our independent witness ki on
PW 5.
PW 5. Okay. So that is the oral dying declaration.
And also another doctor, if you lordship.
Doctor has also recorded.
That is also, that is some faulty. I will demonstrate. Doctor, you lordship.
अरे doctor record करछन ना, doctor भी मौखिक कहउछन.
Doctor deposition कहउछन मु देखली बेड टिकट लिखा है.
बेड टिकट लिखिछन. So it's a written one. All right. Say doctor केते नंबर साइड.
आगे सेटा को माने
PW 1 ये लॉर्ड.
1
डॉक्टर
आगे.
Okay.
महेश प्रसाद बहेरा.
PW 1 डॉक्टर अच्छा. ये गोटे गला. ओरल डाइंग डिक्लेरेशन दि जण पाखरे, रिटन डाइंग डिक्लेरेशन रेला PW 1 डॉक्टर. आउ ता छडा कोन अछि कोन? Leading to discovery, extrajudicial confession.
Extrajudicial confession was made. The PW 8 turned hostile before the IO.
जो मन hostilities छाड़ दियन, जो माने कहिचंती माने
सेति के आगे तीनटा आगे.
And what about the last scene?
Last scene, my lord, No, there is no last scene.
No witness was stated that
देखी नांदी कि जालिबार हाँ
आपण बा the moment जो अनुଯାयी आपणकर पार्टी सुनिले ସେମାନେ ଯେତେବେଳେ spot କୁ ଗଲେ ସେମାନେ you are found present there
present there
ଆପଣ କେସ୍ ହଉଛି ଆପଣ ମାର୍କେଟ ରୁ ଆସିଲା ବେଳକୁ ସେ ଅଲରେଡି ପୋଡି ହେଇଯାଇଥିଲା
ପୋଡି ହେଇଯାଇଛି
ରାଇଟ୍
ଆଜ୍ଞା
ସେମାନେ କହୁଛନ୍ତି ଯେମିତି ଆମେ ଚିତ୍କାର ଶୁଣିଲୁ ସ୍ପଟ କୁ ଗଲୁ ଯାଇ ଦେଖିଲୁ ଯେ ସେ ପୋଡି ହେଇକିନି ଅଛି ଆପଣ
ଏବଂ ଇନଫରମାଣ୍ଟ କହୁଛି ଏଫଆଇଆର ରେ ମତେ ସେ କହିଲା ଯେ ମୋ ସ୍ୱାମୀ ମତେ କିରୋସିନ ଢାଳିକି ପୋଡିଲା but the same while deposed before the London court he didn't whisper about
it's all right he has turned
yes.
those time but again this PW that is PW5
Miller
oh PW5 did not informant did not support the prosecution
yes
case.
But he did not declare hostile court did not declare him
Okay,
hostile
let us
रामनाथ टोपो से कहला जे मो आगे कहला बहुत लोग उपस्थित थिले गुडू भीम राजेश सब थिले मते पचरी
no please come to that PW5 if
yes.
you are placing that PW5 come to
no he is confronted by FPP
अपन कहले hostile हेनी आसिले PW5
ये तो जजमेंट से लेखि ना
ओ आपण एविडेंस रु देखिबेनी आपण स्पेसिफिक स्टेटमेंट दोउचंदी जे PW5 has not supported the prosecution case in spite of that he has not been declared hostile by the prosecution you please
sir,
come
sir.
to the evidence
yes
of
page
PW5
41
yes
page 41 minute
read that
I know the accused and his deceased wife who were staying in a rented house near my house last year on the next day of Deepavali, that is 22nd day at about 12 to 12:30 p.m. by hearing some sound from the house of the accused, I rushed to his house and saw his wife was covered with one blanket as she sustained burn injury. The accused was also present there. Thereafter, I informed the police station over telephone and the police arrived at the spot. After arrival of the police, a written FIR was given. It was prepared by a person at the spot and I signed over the same after knowing the contents as correct. I personally read the same and put my signature. Exhibit 7 is my signature over the FIR. Para 2. My brother, Premanath, Malad PW7, Mahendra Tiwari, PW13, Bhima Lakra and PW11, and others were present at the scene of the occurrence.
ସେମାନେ କି examine ହେଇନା
ହେଇକିଛନ୍ତି hostile ହେଇଛନ୍ତି
କିଏ
ପ୍ରେମନାଥ PW7 co villager
PW7 ତାପରେ ମହେନ୍ଦ୍ର
PW13 hostile co villager
yes then
ଭୀମଲାକ୍ରା PW11 जो माने एफआईआर समरे ठिया ହେଇଥିଲେ ବୋଲି ଗାଁ ଲୋକ ଏଫଆଇଆର କହୁଛି ସେମାନେ
you are present at the scene of
occurrence I heard from the person present at the spot
okay
that the accused set fire to his wife and accordingly I lodged the FIR stating the same where he stated in the FIR that I have heard from the victim. The PPP submitted that witness has made the statement FIR stating that he has personally heard from the deceased about this, but now the witness is also supporting the same. Kindly see next page.
So he was declared hostile and cross-examined.
Cross-examined by when I reached the spot, the accused also trying to extinguish the fire.
No, but he has stated, I had not heard from the mouth of the deceased that the accused set fires once, so but the same has been written in the FIR and I signed the same knowing as correct. Okay. Okay. In the cross-examination by the when I reached at the spot, the accused was also trying to extinguish the fire and he also sustained injury on his left palm. His pant was also burnt near the knee while trying to rescue his wife. I read the FIR, probably had not understood the entire contents of the FIR. Okay. So, this is the evidence of that witness who in the FIR stated about something, but in the evidence is twisted it to say that I heard from others that
my lord, this statement also create doubts about the manner method. Last occasion my lord also put a question about the bed ticket also. My lord was pleased to direct
place whichever whatever
yes
you want to place PW1
yes
okay
no incriminating about the dying declaration, but they have stated that I am permitted to read. Page 34, my lord.
Yes.
On 22nd October 2006, while I was performing duty as casualty of IGH Rautla at 1:20 p.m., a patient, namely Mini Lakra, wife of Mohan Lakra and Rugadi Tola, Vedavas Rautla, was brought to IGH casualty by one Mahindra Tiwari. As the patient sustained nearby 60% burn injury, I examined the patient and made entry in the uh, medico-legal register of IGH casualty. She was admitted in burn center of IGH Rautla as indoor patient. While undergoing treatment, the patient succumbed to her injury on 30th of October 2006 at 5:50 a.m. The cause of death was due to her burn injury. Exhibit 1 is my admission record prepared by me on the date of admission of the patient. Para 2. On 23rd-10-2006, I provided treatment to the injured and prepared the bedhead ticket, which is part of Exhibit 1. While examining the injured, I found smell of kerosene from her body, which I had mentioned in the bedhead ticket. At the time of admission, the patient was conscious. They noted in the bedded ticket that the cause of burn injury was due to pouring of kerosene by the husband of injured at 11:30 a.m. at her residence and setting her fire by burning wood from the chula.
By bringing
bringing wood. Sorry. I have mentioned the same at the time of admission over the bedded ticket. So far I remember, I noted the same as per the version of injured patient exhibit 1/1 and exhibit 1/2 are my signature over the admission record and also the bedded tickets. Next, after admission, I received the requisition from the police and gave injury report on 18/2/2007. I had noted the following injury over the report. Deep burn injury over face, both of her limbs, anterior or posterior aspect of the trunk, causing 55 to 60% burn injury, thereby of the injury, which was grievous in nature. Hatha Dwalini Inguti. Exhibit 2 is the injury report submitted by me, Exhibit 2/1. My lord, cross-examination by defense. Exhibit 1 was prepared separately, and the same is not the extract of medico-legal register maintained at IGS. It is not a fact that I have not mentioned that the patient was a state of mental fitness over the bedded ticket. It is a fact that I have not specifically mentioned over the bedded ticket that under whose instruction or version I quoted the cause of injury sustained by the injured. I had not obtained the signature or thumb impression of the injured over the bedded ticket after admission of the injured. I got the requisition from the police, but I cannot say whether the same was received on the date of admission pattern. It is not a fact that the
where is that portion bedded ticket exhibit exhibit
Exhibit 1, your lordship.
exhibit double list hour trial court courtroom. Exhibit 1. List of exhibits.
If there also permission, I will also demonstrate about the negligence part of the
Wait, court लिखा इसे portion दा. କୋଉ ତାରିଖରେ ସେ ଏଣ୍ଟ୍ରିଟା ଅଛି?
ଆଜ୍ଞା 22 ତାରିଖ 22/10/2000 22/10/2006 admission record
22/10/2006
अच्छा
admitted ସେଟା ଦିଟା ହସ୍ପିଟାଲ ଆସିଲା ଫାଷ୍ଟ ଗୋଟେ ଯାଇଥିଲା ଆଜ୍ଞା ସେଠୁ ଫେରେଇ ଦେଲି ତାପରେ ଏଠିକି ଆସିଲା
alleged got burn injuries today at her residence at Rugudi Tola around 11:30 a.m.
ଆଜ୍ଞା
while her husband put kerosene over her
ଆଜ୍ଞା
and burnt her in the lighted wood from the chalk.
ସେଇଥିରେ ଡକ୍ଟର କହିଲେ ମୁଁ as per remember ସେ ମତେ କହିଥିଲା exact verbatim ଟା ରହିଲାନି କି thumb impression ନେଲେନି କି other staff ର signature. That is the one type of dying declaration which all in trial court has led. This is the bed. Thereafter, my lord, kindly see next page. How it is a medical negligence I can demonstrate.
Who has maintained this? ଏଇଟା କଣ ଡକ୍ଟର ସେ ନିଜଙ୍କର ନିଜର ଇଏ
ହଁ ନିଜର
handwriting?
ସେ ଆଜ୍ଞା ନିଜେ ଲେଖିଲେ
କହିଛି
alleged got burn injury today at her residence at Rugurtola, admitted 11:30.
No, by that time,
My lord.
you see, whether any requisition was sent for recording the dying declaration.
No, that is not there.
So right, କାରଣ ଆପଣଙ୍କର କେସ୍ ଟା ରେଜିଷ୍ଟର୍ଡ ହେଇଛି ଯାହା ଜଣା ପଡୁଛି 22/10/2006 1:15 ହେଲା ଏଇଟା 1:20 ସେ ସେତେବେଳକୁ ହସ୍ପିଟାଲାଇଜ ଅଲରେଡି ହେଇଯାଇଥିଲା ଏବଂ ହଁ ଏଇଟା ଏଇ ଯୋଉ ଏଣ୍ଟ୍ରିଟା ହେଇଛି ମେଡିକଲ ଲିଗାଲ ରେଜିଷ୍ଟରରେ ଏଣ୍ଟ୍ରି ହେଇଛି
1:20
ହଁ so your submission that it should have been recorded in verbatim and number 2 that the signature and thumb impression that is missing and no person has stated neither any staff or any other person who accompanied the deceased to the hospital has put the signature or has stated that any such declaration was made.
Yes.
So have you brought on this record from the evidence of PW1 that others were present who were present at the time when the deceased made such a statement which he recorded in the bedded ticket? जे नर्स माने थिले
my lord, kindly see that nurse se part nahi
आपण आनिबे किए जेरारे आपण आनिबे ना किए आनिबे
yes that is
तो जदि आपण कहउछंती जे जणे डाक्तरंकर किछि आपणकर तो पर्सनल किछि होस्टिलिट नथला बा तार किछि पर्सनल इंटरेस्ट नथिला आपण को फॉल्सली इंडिकेट करिया को आउ सेटा ऑर्डिनरी
with lord kind's permission she was sometime it is depo that conscious very day also IO he stated unconscious. There are two contradictory things are there. I'll demonstrate, my lord. And the my lord, the learned doctor, though my lord had treated and got admitted her, the not record the exact verbatim.
that you have stated already.
And my lord, kindly see the bedhead ticket. That is one important aspect, though may not be helpful for my case. I have to improvise. But the manner where the treatment was undertaken, she could have may not survived.
No, that will come later.
That's a different matter.
खाली देखिए देवी मिलर्ड ब्राह्मणी तरंग को
Have you brought this in evidence?
Don't mix up the thing. You are harping on a particular point. You have stated that so far as the dying declaration stated to have been made before PW5, who has stated so in the FIR, is not believable because that witness himself during evidence in court has not supported that part and stated something different.
Yes.
Now you, without going to the other evidence, was also stated about the oral evidence.
Sorry,
that is PW14. You have come to this written portion. Written dying declaration, we find that PW1 has mentioned about the same in the bedded ticket and how she received the because in the it's a burn injury case and obviously they have a right to know that whether it was an accidental one or it is a suicidal one or somebody has set her fire, and accordingly they used to give information to the concerned police station because it is not a case that the deceased came to the hospital on police requisition. She on her own accord came. Is it not correct? अरे deceased निज तरफ आसिला तेणु सेठी जेतेबेले आसिला एमाने जानिला परे the moment they found that it is a medical legal case they are to inform to the nearby police station. Okay, तेणु एठी तारो एठी लेखिवार बा जानिवार पचारिवार उद्देश्यटा होची टू नो दी करेक्ट स्टेट ऑफ अफेयर बर्न इंजुरी आपण देखिबे मेडिकल जूरिस्प्रुडेंस रे मध्य से विषय उल्लेख अछि मोदी ट्रेलर रे सब अछि जे जोठी बर्न इंजुरी केस आसीबो डाक्तरंकर ड्यूटी कोन फास्ट आपण एसर्टेन करिवे जे केमती एटा हला द मोमेंट दे फाउंड that it is a medical legal case they have to intimate to the nearest police station so ए डॉक्टर यार को पचारिवार किछि भूल करनी बा से जहा पचारि किन से जा लेखि छंती सेटा को उल्लेख करिवार बेड टिकेट रे तांकर किछि इलीगलिटी कमिट करना
Okay, that
right
that will also. Then I will demonstrate page W13.
and if you say that
Hmm.
that victim was not conscious
Yes.
so where is that material
Yes, I will bring. My lord, I'll bring to lordships.
have you suggested to the doctor who stated to have recorded that no you have falsely recorded the victim was not conscious and he was in unconscious state एमती किछ पचारचन डॉक्टर जी रेकॉर्ड कला बेड एटी
not mentioned that the patient was at a stage of mental weakness over the bed at ticket. Bed at him लेकिन कल पचारचन.
it is not a fact that the patient and accompany has not stated anything before me regarding the burn injury suggestion টা দেইছেন
Suggestion is a mental fitness stage. Patient was
Aja.
at a stage of mental fitness over bedded ticket. It is not a fact. Suggestion টা রয়েছে.
you see 22 ए recording केबे हला एटा 22 तारिख रे ए गोटे 20 रे आपण दुईटार एंट्री देखन सेई आउ जस्ट अधघंटा पर एंट्री history as noted by the casualty medical officer date of born so and so and patient is conscious pulse rate not so and so not readable gacha then dehydration so and so chest clear burn injuries on the face then out of one portion लगाई upper limbs anterior and posterior aspect of trunk बोधे लगाई so and so 55 to 60% burn injuries तापरे advice गुड़ाक दिया इची कौन टैबलेट खाइबो कौन लगेबो ए सब दिया इची so dressing ପାଇଁ ତାଙ୍କୁ advice ଦିଆ ହେଇଛି injection ଦିଆ ହେଇଛି then again ସେଇ ଦିନ 4:30 ର entry ରହିଛି patient conscious again ଲେଖା ହେଇଛି ଉପରେ top ରେ so pulse not palpable ତାପରେ blood pressure not readable chest and so
So 13 ଆଉ 14 ଟେ malad I'll bring you lordships kind.
13 14 କଣ
ସେ ଦିଟାକ ସେଇଟା କଣ୍ଟ୍ରାଡିକ୍ଟ କରୁଛି ଏବଂ ଅନକନସିୟସ୍ କନସିୟସ୍ ପାର୍ଟ ଟା ବି ରହୁଛି ଗୋଟେ ପୋଲିସ ଅଛି ଆଉ ଗୋଟେ ମହେନ୍ଦ୍ର ତିୱାରୀ
no if let us say PW5's version is something different but the IO has also ascertained from the this deceased you said that the before the IO also same statement has been made come to that IO evidence
IO again
PW 14 na 15
14
let us say see what he has stated
এটা 14 ne milord kindly see the last bottom two line
page 53 to
ଆଜ୍ଞା so देखो as flood bottom ର the line as the injured became unconscious at IGS the MO could not record her dying declaration on which is mentioned categorically over my requisition exhibit 13. If you will not altogether, I
No,
permit
you
to read.
come prior to that. You
Yes, I will read.
line.
Enter.
Yes.
Yes.
I went there, examined her, recorded her statement under section 161 CRPC. She was talking in a very low, slow voice and was undergoing treatment at IGH.
I issued requisition to MO IGH Raukla to record the dying declaration of the injured Mini Lakra by requisition exhibit 13. Exhibit 13 by 1 is my signature thereon. I also issued requisition to the MO IGH Raukla for treatment of the injured by exhibit 2 by 2. Exhibit 2 by 3 is my signature. There was an attempt for recording. As the injured became unconscious at IGH, the MO could not record her dying declaration, which is mentioned categorically over my requisition exhibit 13. I returned to the
No, see you 161 ta record kala. What is that exhibit? Because that can be treated as
Seta asini again.
Kon asini?
Exhibit ta
no. 161 ta praman hai nahi. It should be marked as an exhibit.
Yes.
Why it has not been marked?
Seta kahin lekha hai nahi. I went to there and examined and record the statement 161 CRPC.
The statement ever lekhi
She was very low voice.
You come to paragraph number 5. At the time of recording of the initial statement, read that portion.
At the time of recording of the initial statement of the injured deceased Mini Lakra, she disclosed before me that she, being the second wife of the deceased accused, he was always quarreling with her. On the day of incident at about 12:30 p.m., he started quarreling with her and suddenly he got annoyed by saying to kill her. Me, accused poured kerosene over her body from the plastic bottle and set fire to her by bringing one burnt wooden piece for which she sustained injuries. She then raised alarm and some neighbors took her to IGH. This statement is recorded with objection by defense counsel, which it again mark exhibit.
No, this is not admissible. This is not. It should have been marked as an exhibit. He has because of the law laid down by the Honorable Supreme Court that the statement that in this only in this exceptional circumstances when it relates to the cause of death that 161 can be used as dying declaration.
ସେଟା ମିସିଂ ଅଛି ମୁଁ ଦେଖୁଥିଲି ସେଟା ଏକ୍ସିବିଟ୍ ହେଇଛି କି ନାହିଁ
No, এটা এই objection কলে পরে trial court সেইপাই objection should have been overruled because of the decision of the Honorable Supreme Court and it should have been marked as an exhibit or at least marked an exhibit with objection ଯାହା ହେଲେ ବି ଗୋଟେ ପରେ decide ହେଇଥାନ୍ତା total mark ନ କରିବାଟା ମାନେ ଠିକ କଲେନି in view of the settled law and that statement is very clear. Now if you have you think in another angle, if you have she has tried to commit suicide and you are saving her life, why did she will tell falsehood before implicating her husband who tried to save her life that my husband poured kerosene on me and set fire to me?
That 161 statement was recorded. 161 statement of the victim, she stated that yes, my husband has poured kerosene.
Yes.
And the person who lost the affair, he was also present. Initially he heard. There is contradiction. I bring to your lordship that the full of contradiction and the dying declaration is not having sanctity. So the dying declaration would have been clearly requisition would have made if she is conscious, the dying declaration would have recorded.
No. You see, as it appears that time to time her condition deteriorated. Right.
Sometimes
so that happens in born injury case because it goes by the time septicemia, all these things time to time it occurs. So initial stage re jo response thila sei response pare hue to nathibo jyoti pai though he has prayed for recording of the dying declaration, it could not be made, otherwise it could have been recorded. Otherwise the first instance when she came, by that time there was no information that FIR was lost, has already been lodged in some police station. He came straight away, he was admitted because it is in such a case, cannot say that you first lost the FIR, then we'll treat it. So first the doctor's duty is that to treat the patient.
It is a fact that she has no relative or no but side there is no
The husband has not come to the
hospital.
he should have, if
yes
he should have the very
Present.
first
Yeah,
person
that is
to
no evidence.
accompany his wife to the hospital.
Rather other
That conduct shows itself that what you are.
yes that he was not present at the hospital. He was taken into custody just 2 days after.
No.
He was very much
He was
present at that
present
time.
at the scene of the occurrence.
Scene.
So
Then-
when the others carried the deceased to
Yes.
the hospital, why he did not accompany them
Milord,
to the hospital?
Milord, that he was present at the when he rescued.
Yeah.
Villagers took her. Villagers took her. But there is a missing of evidence that he was accompanied. That part is blood. But it is a fact, some evidence that he was present. He was trying to save her life by blood putting a combat and also trying. That is also some evidence also.
Mr. Mishra, law is very clear that even if there is no evidence, if the dying declaration is accepted by the court to be reliable, trustworthy, on that
Sure.
basis alone, the
Yes.
one can be convicted.
But here my
Right.
case, I will demonstrate by citing some judgments where the dying declaration has no sanctity. In this case, the manner the prosecution has conducted, the doctor's statement, the IO's deposition,
And it is a case of, just think over it, is a case of 50 to 60% burn injury.
my lord.
Even there are cases up to 90% burn
Yes.
injury in which the dying declaration has been accepted, because it depends upon person to person that how they will respond. Upon koi paribeni je 50-90% ହେଇଗଲା ମାନେ ସେ totally ତାର ଇଏ କରିବେ
ହେଇଛି
ଜଣଙ୍କର ରେଜିଷ୍ଟାନ୍ସ ପାୱାର କେତେ
Honorable
ତାର-
Justice Kaulଙ୍କ judgment ଅଛି 93
ତେଣୁ ଏଠି 50 to 60% ରହିଲା ଏବଂ that lady survived for 8 days.
Yes.
And the report, bedded ticket report also indicates that after making such statement, other doctors have also come and they have noted down that the patient is conscious. It is not that particular doctor has made
Yes.
entry.
sure.
Your bedded ticket has been made, entry has been made by
Other
number of doctors. Okay. ସେମାନେ ମଧ୍ୟ ଲେଖୁଛନ୍ତି patient conscious ଅଛି।
Conscious.
ତାହେଲେ ସମସ୍ତେ କଣ ଆପଣଙ୍କ ଏଗେନଷ୍ଟ ରେ ସମସ୍ତେ ଲେଖିଦେଲେ ସେ କଥାଟା ହ୍ୱାଟ ଆଇଓ ର କଣ ଥିଲା ପର୍ସନାଲ ଇଣ୍ଟରେଷ୍ଟ, why you would record such a statement, and what questions you have put in the cross examination. It's all right that is not marked as an exhibit,
Yes.
but let us say that oral evidence of the IO in that
ସେଇ
respect
ଯୋଉ
is-
ଆଇଓ ର ଆଜ୍ଞା PW14 ର ଟିକେ ମୁଁ ଦେଖୁଛି ପାରା 7 55
Yes.
3 ପେଜ ର
Hmm.
my submission exact verbatim will not recorded, though medical staffs are present,
You
their
see,
signature are not
no,
taken,
no, just
and thumb impression also not taken. If hadid the because
listen to IO ପାଖରେ ଯୋଉ statement ଟା disease ଦେଲା
ଆଜ୍ଞା,
ଏଇଟା ଯଦି normal witness ହେଇଥାନ୍ତେ ଯୋଉମାନେ ଏଇଟା ହୁଏତ 161 admissible ନୁହେଁ ଆପଣ କହିଥାନ୍ତେ,
ଆଜ୍ଞା.
but there is an exception when he makes a dying declaration and subsequently dies.
But they have not
So-
been exhibited, though. The
Leave that
prosecution-
portion. We are asking you about the oral statement which has been made before the IO. এই जो oral statement টা দেলা, which is taken down in writing, but that writing has not been exhibited. That's a different aspect. So, but this oral statement which has been made before the IO also,
my lord.
it is also the dying declaration. ସେଠି ମଧ୍ୟ ସେ କହିଛି ଯେ ମତେ ଏମିତି ମୋ ସ୍ୱାମୀ ଏମିତି ପୋଡ଼ି ଦେଲେ. So that is admissible.
That when she was survived for 8 days and
Yes.
she was conscious,
Hmm.
and it is Milord missing the prosecution
No,
taken all
conscious-
endeavor to record a Milord this
Conscious
the dying declaration should have some sanctity. If
Through-
Milord police
throughout
would have
conscious
recused
ନଥିଲା, you find out that subsequently their condition
ସେଇ ଦିନ ଆଜ୍ଞା
deteriorate
ସେ
କରିଛି।
ସେଇ ଦିନ ସବୁ
ଆପଣ-
ପୁଲିସ
ଆପଣ ବେଡେ
ପଳେଇଛନ୍ତି,
ଟିକେଟ
22 ତାରିଖ
entry
ଦିନ
ଦେଖି-
ସବୁ ମୁଭମେଣ୍ଟ କରିଛନ୍ତି।
ଆପଣ 22 ତାରିଖର ପରେ condition ତାର ଦେଖୁଛନ୍ତି,
ସେ ବା
ତାର condition deteriorate କରୁଛି time to time ଦେଖନ୍ତୁ।
ଡକ୍ଟର ଲେଖିଲେ ବ୍ରାହ୍ମଣୀ ତରଙ୍ଗ ତମେ ଆସ, ତାକୁ ଟଙ୍କା ଦିଅ, ଡିପୋଜିଟ କର, ପଇସା ଦିଅ, they have not taken that part.
ତେଣୁ ସିଏ ଡାଏଟ ବି ନେଇ ପାରୁନି, ତାର ଅନ୍ୟାନ୍ୟ condition
ପେମେଣ୍ଟ ଅଫ ବିଲ୍ ହଉନି, ନାଟେନାଣ୍ଟ ନାହାନ୍ତି, ଗୋଟେ ସବୁ ଲେଖା ହେଇଛନ୍ତି, ଡକ୍ଟର ଲେଖିଛନ୍ତି ସବୁ। So the police pillars stated, I visited her, the duty staff were present when I recorded the statement of victim, but I have not recorded any statement of said duty staff. I did not. My lord, right, you know, there's some, you know, the Proposition, Lord, my lord,
No, no,
absolute correct. I word on to your lordship,
are you advancing an argument
my lord.
that if a separate dying declaration is not
Yes.
recorded, but in the bedded ticket it has been mentioned, it should be taken out of consideration? Is it your submission?
My lord, my submission, when there are ample scope and the my lord time and the everything was there, the prosecution could
ଆପଣ
have
ଯୋଉଟା କହୁଛନ୍ତି ଯେ ଡାଇଂ ଏଇ ଯୋଉ ସାକ୍ଷୀ ମାନଙ୍କର ଦସ୍ତଖତ ନିଆଇଥାନ୍ତି ସେଟା ଯଦି ଡାଇଂ ଡିକ୍ଲାରେସନ ଫର୍ମରେ ଲେଖା ହେଇଥାନ୍ତା ଯୋଉଟାକୁ ରିକ୍ୱେସନ ହେଇଥିଲା ସେଠି ଓବିୟସଲି ସିଗ୍ନେଚର ଥାନ୍ତା ତାର ଇଏ ଥାନ୍ତା ବଟ୍ ବେଡେଡ୍ ଟିକେଟ୍ ଇଜ ସମଥିଙ୍ଗ ଡିଫରେଣ୍ଟ ଦ୍ୟାଟ୍ ଇଜ ଟୁ ବି ମେଣ୍ଟେନ୍ ବାଇ ଦି ଡକ୍ଟର୍ସ ସେଠି କୋଉଠି ଆପଣଙ୍କର ରହିଛି ଯେ ସେଠି ଯଦି ଷ୍ଟେଟମେଣ୍ଟଟା ତାର ରେକର୍ଡ କରାଗଲା ତା ଜାଗାରେ ଆପଣଙ୍କର ନେବେ ଏଇ
ଆଜ୍ଞା।
ମୋଦିର ଜୁରିସ୍ପ୍ରୁଡେନ୍ସଟା ଦେଲେ ମେଡିକାଲ ଜୁରିସ୍ପ୍ରୁଡେନ୍ସ ଥିବ ସେଇଠି ଦେଖ ଏଇ ପାଖରେ କୋଉଠି ଥିବ ସେପଟେ ଥିବ ଦେଖ
ଏମିତି ନୁହେଁ ସେ
ମୋଦି ଥିଲା ଟେଲର ଥିଲା ସବୁ ଠିକ ଅଛି
I have a copy if you lordship.
ମେଡିକାଲ ଜୁରିସ୍ପ୍ରୁଡେନ୍ସ
Lordship.
ମୋଦିର ସେଟା ବାହାର କରିଦେଲେ ସେଇ ଯୋଉ ଚାପ୍ଟରଟା ବର୍ନ ଇଞ୍ଜୁରିର
Lordship.
ପଢନ୍ତୁ ଆପଣ ଯଦି ପାଇଲେ କଣ ହଁ ଏଇଟା ମୋଦିର ତ
Page 629, your lordship.
just a minute let us Born- born সেটা 624
basic judgment ଟା ଛତିଶଗଡ଼ ଦେଲେ ତାପରେ 97 କେସ୍
Have you got it, Mr. Mishra?
Lordship.
please
Please read it.
Lordship wants me to read the
ସେଇ ଯୋଉ
That particular manner of recording.
in the bedded ticket
Lordship. I haven't found that yet.
Oh,
ଅଛି specifically ଅଛି instruction ଯେ that can be recorded in that bedded ticket also ତାର ଗୋଟେ ଯୋଉ ଲାଷ୍ଟ ପେଜ କୁ ନଥାଏ ଏଇ ଯୋଉ ଇଣ୍ଡେକ୍ସ ଟାଇପ ର
Lordship.
ସେଇଥିରୁ ଦେଖନ୍ତୁ ଡାଇଂ ଡିକ୍ଲାରେସନ ଦେଖନ୍ତୁ
ଚାପ୍ଟର 21 ଦେଖିଲେ ବର୍ନ ଇଞ୍ଜୁରି
ନାଇଁ ନାଇଁ ବର୍ନ ଇଞ୍ଜୁରି ତ ଅଛି bedded ticket born injury ସେଠୁ ଦେଖିଲେ ମିଳିବ এটা মনোপাত্র ভাগ করো Ready up. এবং তো টাইপ করো অনুসার କେସଟାରେ ଦେଖନ୍ତୁ ସମ୍ ଅପ୍ କରିଛନ୍ତି ଡାଇଂ ଡିକ୍ଲାରେସନ ଆସ୍ପେକ୍ଟଟାକୁ so many decision has been quoted down by the Honorable Supreme Court. There is neither any rule of law nor of prudence that dying declaration cannot be acted upon without corroboration. If the court is satisfied that dying
Yes,
declaration is true and voluntary, it can base a conviction on it without corroboration.
पुरुषोत्तम चोपड़ा
The
case.
court has to scrutinize the dying declaration carefully and must ensure that the declaration is not the result of tutoring, prompting, or imagination. The deceased had opportunity to observe and identify the assailants and was in a fit state of mind to make the dying declaration. Where the dying declaration is suspicious, it should not be acted upon without corroborative evidence. Where the deceased was unconscious and could never make any dying declaration, the evidence with regard to it has to be rejected. A dying declaration which suffers from infirmity cannot form the basis of conviction. Merely because a dying declaration does not contain the details as to the occurrence, it is not to be rejected. Merely because it is a brief statement, it is not to be discarded. On the contrary, the shortness of the statement itself guarantees truth. Normally, the court, in order to satisfy whether deceased was in a fit mental state to make the dying declaration, look up to the medical opinion. But where the eyewitnesses have said that the deceased was in a fit and conscious state to make this dying declaration, the medical opinion cannot prevail. Where the prosecution version differs from the version given in the dying declaration, the said dying declaration cannot be acted upon. So this was this has been summed up from different decisions. This is the case of Amit Kumar.
But we have specific cases in burn injuries. Recording of dying declaration in specific cases of burn injuries.
Punjab. This is reported in 2010, 12 SCC 285. Okay. Now, there are 3 decisions of our court also where a ticket ଉପରେ okay 23 ଅଛି ମାଳତୀ ମହନ୍ତ vs State of Orissa ଦେଖିବା ଏଟା third decision କଣ ଦାସ SK ପାଣିଗ୍ରାହୀ is in fact the predicate in this case, although the time of discharge is not put on the date that is not whether ticket transfer has neither been seized nor put. That is a different case. Okay. Next case. Because it's not going to get a ticket holding. The so-called dying declaration recorded to appear in this also has been admitted in written mark and the bed ticket of the deceased and contentment have also been admitted as one. So, okay. The oral dying declaration, the recorded dying declaration for the executive. Other than the bed ticket mentions nothing. The deceased was not in for that exam.
LPW6 has not come forward.
Okay, so this one
Saved us.
down to the So what are your points, Mr. Mishra? You have summed up in that written note of argument.
My lord.
What you have stated that
It-
why this
Willard,
dying declaration is to be discarded.
The dying declaration has no sanctity. First of all, the dying declaration has Willard, no corroboration. And though Willard, she was in state of mind, no endeavor was taken by the police prosecution to take her fingerprint and to take her.
No, dying declaration no corroboration nahi mane kemti kହୁଛନ୍ତି. Dying declaration ne କହିଲା ଯେ ମତେ ସ୍ୱାମୀ ପୋଡ଼ି ଦେଲେ ଏବଂ ସେଇଥିପାଇଁ ମୋ ଅବସ୍ଥା ହେଲା. That is doctor statement is there, postmortem report is there.
Who else could have?
So ଆଉ କଣ corroboration ଦେଇଥାନ୍ତେ? ଆପଣ ଦି ଜଣ official witness ମଧ୍ୟ କହୁଛନ୍ତି.
ଆଜ୍ଞା.
ଡକ୍ଟର କହୁଛନ୍ତି ଏବଂ ଆଇଓ ମଧ୍ୟ କହୁଛି ଯିଏ କି ତାଠୁ ଶୁଣିଛି ହେଲା. ଆଇଓର yes.
Para 3. The present case, the prosecution has failed to establish the mention of the accused appellant person in the alleged crime and has failed to prove all the circumstances witnesses beyond reasonable doubt. The prosecution also failed to establish a chain of circumstances which the guilt is to be drawn by the court. The London trial court.
No, mensiria କଣ କେମିତି absence ଅଛି? If the dying declaration is accepted, ଆପଣ ଜଣକୁ କିରୋସିନ ପକେଇବେ ଆପଣଙ୍କ ସ୍ତ୍ରୀକୁ, ତାପରେ ତାକୁ set fire କରିବେ, ଆପଣଙ୍କର ଆଉ କଣ ଥାଇପାରେ ଆପଣଙ୍କର ingredients?
ଆଜ୍ଞା, police ଆଗ record କଲେ statement ତାର 161 ଯେ ମୋ ସ୍ୱାମୀ ମତେ ମାରଲା. That statement has not been exhibited.
We can exhibit it. There is no problem with that. We can do it.
Again.
That IO or any other person, that is not the
390, your lordship.
Additional evidence can be recorded. That can be exhibited. There is no problem in that.
And the PW5, though may not turn hostile, but the hostile evidence has also some. The court, Honorable Supreme Court, has also stated some portion of the Millard they cannot be totally discarded. I will come to lordship that the hostile witnesses also have some importance. The PW5 Millard, who initially stated that the deceased has disclosed before him that yes, my husband has poured kerosene, but subsequently he didn't.
Now, that part of evidence is not necessary. The part of evidence which supports the prosecution, and on that you have cross-examined. That is the part to be taken.
And the doctor, Millard, PW1, yes, he not brought in a conscious position. There may not be any other person accompanying of the family, but other persons who are present, who Millard PW5, PW11, PW13, all were Millard, they are present in the hospital.
Who has said this?
They all carried the.
No, you cannot say. Who were present?
I get lekhile ame asiru nei kiri samaste hospital ko debo.
No. At the doctor's room where she was taken, whether all these people were present?
13.
They must have carried the injured.
PW13. PW13.
ସେ ଟାଇପ ର କେସ୍ ରେ ଆପଣଙ୍କର ପେସେଣ୍ଟ ପାଖକୁ ଅନ୍ୟ ମାନଙ୍କୁ ନିଆଯାଏନି, ତାଙ୍କୁ ଇନଫେକ୍ସନ ହବନି. କଣ କହୁଛନ୍ତି? ମୋ ବର୍ନ ଇଞ୍ଜୁରୀ କେସ୍ ରେ ତାଙ୍କୁ ଅର୍ଡିନାରିଲି ତାଙ୍କ ପାଖକୁ ନିଆଯାଏନି, ସେପ୍ଟିସେମିଆ ହେଇଯାଏ, ଅନ୍ୟାନ୍ୟ ପସିବିଲିଟି ଅଛି, ତାଙ୍କୁ ଆଇସୋଲେଟେଡ କରି ରଖାଯାଏ, ବହୁତ କେୟାରଫୁଲି ଡିଲ୍ କରାଯାଏ. ନଟ୍ ଦ୍ୟାଟ୍ ଇଟ୍ସ ଏ case of like other patients.
But
we shifted her to RGH, Rourkela Government Hospital. Then she was shifted to IGH. But due to refusal, we took her to IGH.
Yes, but the attendant may not be
at the time of admission. The deceased was talking faintly and was shouting due to pain. This is there. This is PW13.
So my submission, Millard, even if doctor has Millard mentioned in the bed ticket and she was treated inside, but the taking the thumb impression or taking any other assistance of Millard, any nurse or any assistant, the dying declaration is not complete.
Because bed ticket re thumb impression nabba darkar ki koti provision achi bed ticket re separate seat re record hobo, it's all right. ବେଡେଡ୍ ଟିକେଟରେ ତାର ଥମ୍ବ ଇମ୍ପ୍ରେସନ ନିଆଯାଇ ପାରିବ ନାହିଁ ବୋଲି ତାକୁ ଡିସକାର୍ଡ କରିଦିଆଯିବ ସେ ଡାଇଂ ଡିକ୍ଲାରେସନକୁ. ଏଭଳି କୌଣସି ଇଏ ରହିଛନ୍ତି? ଯଦି ଇଫ୍ ଅଦରୱାଇଜ ଇଟ୍ ଇଜ ବିଲିଭେବଲ ଦ୍ୟାଟ୍ ଦି doctor's version regarding the statement made by the deceased is believable and he has noted down, he is a government officer, is a doctor, no personal hostility with anyone. There is no reason to somebody falsely implicate the husband. Sei type ro gode doctor, gode government hospital lo deceased version ku record karichi bedhead ticket re. Merely because that she has not taken, maybe it's a, let us say it's a part of omission on the part of the doctor to take the LTI. We do not know whether all the that was there was no
Is in a
burn injury.
position to be taken.
হ্যাঁ যদি সেটা পড়ি যাইଥିବ ମାନେ LTI portion ଟା ତାହେଲେ ନେବେ କେମିତି?
ସେଟା ଆସିନି। Yes.
ଆପଣ ତେଣୁ hypothetically
So the doctor Millard who has Millard as it appears from the deposition Millard, the exact verbatim is not there. He Millard presumed, he Millard kindly repeat my submission, I can repeat, I can remember what he Millard stated that at the time of admission the patient was conscious. The noted that noted in the bed ticket that the cause of burn injury was due to pouring of kerosene by the husband of the injured at 11:30 a.m. at a residence and setting her fire by bringing wood from the chula oven. I have mentioned the same at the time of admission over the bedded ticket. So far I remember, I noted the same version of the injured. So this cannot be a incriminating and cannot be accepted as a sole Blood, a piece of evidence of dying declaration having sanctity. As the doctor may be not independent, may be Dr. Blood, the doctor being a learned and knowing person, the dying declaration could have been complete and taken into Millard having Millard taken into account if it had been Millard the thumb impression as well as Millard the other witnesses, any nurse or any accompanied persons have been taken. And the only PW1 version as a dying declaration, but other Millard, if you are taken to see the other witnesses, other circumstances, Millard, other these are missing and the non-corroboration and Millard the persons which are Millard not accepting whether she was conscious, whether she was non-conscious, whether she has deposed before other witnesses, that part you all demonstrate. There have some blood prosecution has not properly blood achieve the same. So merely because one dying declaration which blood is not made in order, and also the other witnesses also blood they are not supported. Even police officer also stated that the attempt was made for recording dying declaration, but it could not have been done due to the patient was becoming unconscious.
ୟାଙ୍କ ଭିତରେ ଯୋଉ previous relationship ବିଷୟରେ ସେ ବିଷୟରେ କିଏ evidence କହିଛନ୍ତି ଯେ there was quarrel, anything strained relationship ଏସବୁ କିଏ?
No such evidence is there in detail here.
ନାଇଁ ଗୋଟେ line ଅଛି FIR ରେ ଯେ ଆଗରେ ତାଙ୍କ ଭିତରେ
There was a dispute in the previous night, but
ସେଇ ଯୋଉ ଜିନିଷଟା
those witnesses have turned hostile, who have stated that.
ପ୍ରକାଶ ଥାଉ କି ଯେ ଗତକାଲି ଦିନ 3ଟା ବେଳେ ମୋହନ ଓ ତାର ସ୍ତ୍ରୀର ଝଗଡା ହଉଥିଲେ
Yes.
ଏବଂ ସେଥିରୁ ନିର୍ବୃତ୍ତି ରହିବାକୁ ଭୀମ କହିଥିଲା। ଏମାନେ ଏ ବିଷୟରେ କିଛି ଏଭିଡେନ୍ସ ଆସିନି?
No.
Bhima has been examined, no? Bhima has been examined.
Yes.
Not supported.
EW 11.
11, page 49, Millard.
ये जो 161 स्टेटमेंट टा टिके देखिले एलसीआर रू बाहर कले तारो नहीं सेटा नहीं तो ट्रायल कोर्ट रेकॉर्ड रू बाहर तो द एग्जिबिट मार्क इन ये उड़ा अच्छी हार्ड कॉपी थी वो देखिए
एलसीआर
हाँ दिया
ଗୋଟେ ଡକ୍ଟର କହିଛି ସେପ୍ଟିସିମିଆ ହେଲା ନେଗ୍ଲେକ୍ଟ ହେଲା ଯୋଉ କୋଉଟା ପଚରା ହେଇଛି
कौन से डिसीज ना कौन मिनी सब हाँ this was recorded on 22/10/2016 এটা ଅଛି ତା ଦେହରେ ସେପଟେ ଏଇଟା ସେପଟେ ଇଏରେ ବାହାର କଲ ତାଙ୍କୁ ସାର୍ଙ୍କର ବାହାର କଲି ସେ ମିନି ସର ଷ୍ଟେଟମେଣ୍ଟ ଆଉ ଆସିଲା ହଁ ମୋର ନାମ ମିନି ସାହୁ
ଆଜ୍ଞା ପଢୁଛି ମୋ ନାଁ ମିନି ସାହୁ ଓରଫ ଲାବରା ଆଜି ତା 22/10/2006 ତାରିଖ ମୁଁ ଆପଣଙ୍କ ପାଖରେ ଦେବା ବୟାନ ନେଇକି ଯେ ମୁଁ ଆଜକୁ ପ୍ରାୟ 7-8 ମାସ ହେଲା ମୋହନ ସାହୁ ବାହାକୁ ବାହା ହେଇଛି ମୁଁ ଆମକୁ ଝାଡଖଣ୍ଡରେ ବାହା ହୋଇଥିଲି ଆଗରୁ ମୋର 2ଟି ଛୋଟ ପିଲା ଅଛନ୍ତି ମୋର ସ୍ୱାମୀ ମରିଯିବାରୁ ମୋହନ ସାହୁ ମତେ ଆଣି ସ୍ତ୍ରୀ କରି ରଖିଲା ଆମେ ପ୍ରାୟ 3 ମାସ ହେବ ଦେବାଘର ମନ୍ଦିର ରୋଡ ବେଦବ୍ୟାସ ମନ୍ଦିର ରୋଡରେ ଗୋଟେ ଭଡା ଘରେ ରହିଛୁ ମୋହନ ସାହୁ ଠିକ ଭାବରେ କମେଇ କରୁନାହିଁ ସେ ମୋ ସହିତ ପ୍ରାୟ ସବୁଦିନ କଳି ଝଗଡା କରେ ଆଜି ଦିନ ପ୍ରାୟ 12:30 ସମୟରେ ସେ ମୋ ସହିତ ଖାଇବାକୁ ଦେବାକୁ କହି ଝଗଡା କଲା ଓ ହଠାତ୍ ରାଗି ଯାଇ ମତେ ଜୀବନରେ ମାରିଦେବାକୁ କହି ଗୋଟେ ପ୍ଲାଷ୍ଟିକ ବୋତଲରୁ କେରୋସିନ ତେଲ ମୋ ଦେହରେ ଢାଳି ଆମ ଜାଳ ଜଳୁଥିବା ଚୁଲିରୁ ଖଣ୍ଡିଏ ଜଳନ୍ତା କାଠ ଆଣି ମୋ ଦେହରେ ନିଆଁ ଲଗାଇଦେଲା ଫଳରେ ମୁଁ ଗୋଟିଏ ଆଘାତ ପୋଡି ଆଘାତ ହୋଇଛି ମୁଁ ପାଟି କରିବାରୁ ସ୍ଥାନୀୟ ଲୋକମାନେ ଆସି ପହଞ୍ଚିଲେ ମୁଁ ଏ ସମସ୍ତ ବିଷୟ ସେମାନଙ୍କୁ କହିଛି ସେମାନେ ମତେ IGH ରେ ଆଣି ଭର୍ତ୍ତି କରୁଛନ୍ତି ମୋର ସମ୍ପର୍କୀୟ କେହି ନାହାନ୍ତି ପୋଲିସ ଥିଲେ ଏବଂ ଅନ୍ୟମାନେ ଥିଲେ all witnesses how am I ପୋଡିକି ମାରିଛନ୍ତି ବୋଲି statement has been clearly stated
ମୋର ସମ୍ପର୍କୀୟ କେହି ନାହାନ୍ତି
ଆଜ୍ଞା ଆଜ୍ଞା
ମୁଁ ଇମ୍ପୋର୍ଟାଣ୍ଟ ହଉଛି ମତେ ଗୋଟିଏ ପ୍ଲାଷ୍ଟିକ କହି ଗୋଟିଏ ପ୍ଲାଷ୍ଟିକ ବୋତଲରୁ କିରୋସିନ ତେଲ ମୋ ଦେହରେ ଢାଳି ଆମ ଘରେ ଜଳୁଥିବା ଚୁଲିରୁ ଖଣ୍ଡିଏ ଜଳନ୍ତା କାଠ ଆଣି ମୋ ଦେହରେ ନିଆଁ ଲଗାଇ ଦେଲା ଫଳରେ ମୁଁ ପୋଡି ଆଘାତ ଦିସ୍ ଇଜ ଦି ରେଲେଭେଣ୍ଟ ପାର୍ଟ तो सीआरपी स्टडी के बारे में
बट सीजर रे गुडे मैचेस काठी
ना नहीं इवन हाफ बर्न
अछि
वुडन पीस
Yes, that is also there.
गुडे काठी गुडे पडिछि पुलिस सीज करछन्ती
So, Mr. Mishra,
My lord.
now somehow or other it should have been marked as an exhibit, but it has not been marked. And the law is very clear that the statement of the deceased made before the IO relating to her death, that is an exception that can be taken as dying declaration, that can be acted upon. So it can be treated, whether it would be acceptable, there are suspicious feature, all these things are different. But again, if this document has not been marked as an exhibit at that stage, then unless it is brought on record and marked as an exhibit, can this court consider the same?
Lords, the version of the IO, EW14, even if we.
So there is a provision for that additional evidence
Yes,
for
that is the
391 CR.
391.
Not sure.
So you have not come up with any petition of that nature.
My
So
lords.
what is the law that whether merely because a document is available on record, there are many things available in the case diary.
Got it.
So if we'll just admit this document or if we'll mark it as an exhibit, can it be done? And if no opportunity is provided to the other side to cross-examine the IO on that aspect, therefore, sometimes it is stated that when such a petition is filed, either the appellate court is to record the evidence or it can send it to the concerned court for recording the evidence and give that opportunity that will come and then that will be taken. Come to that 391, it's very clear.
Lordship.
In dealing with any appeal under sworn, so the appellate court, if it thinks fit additional evidence to be necessary, shall record its reason and may either take such evidence itself or direct it to be taken by the magistrate, or when the appellate court is a high court, by a court of session. When the additional evidence is taken by the court of session, then or the magistrate, or he shall certify the such evidence to the appellate court, and such court shall thereupon proceed to dispose of the appeal. The accused or the pleader shall have right to be present when the additional evidence taken, and the taking of the evidence under this section shall be subject to the provision of say jera madhya pariparibo. Tenu we cannot we cannot just mark it as an exhibit and use against him unless it is marked. If you, first of all, there is no petition from your side. Second of all, suppose we accept your prayer, then either we are to record the evidence, call that witness, okay, to mark it as exhibit, and you will be given an opportunity to cross-examine, or it has to be sent to the concerned trial court that you mark this document, prove this document through this one, give the opportunity and send that part. So that will be further evidence of this PW 14. So what is your submission on that? Without, this is the law, mandate of law as per 391 CRPC. Unless we comply that provision, we cannot just take into account. Of course, we can take into account the statement which has been made by the IU.
Yes.
That is orally he has stated like that. And is getting corroboration from the bedded ticket entry. That's a different matter. But we cannot say that it has been recorded and in the recorded version it has been stated like this. So this is the difference. If we are going to a next step, of course you have not filed any application, but in case also you file, this should be the procedural as per the CRPC, and we cannot ignore that provision.
At all time, the court also cannot remain as silent spectator. You can take it. You examine this part and you can file accordingly tomorrow.
So can I file an application now?
You can always.
You can operate.
You can always.
There is a provision.
My lords.
But provision makes it very clear. We can record it and we can also send it to the concerned.
We'll send it to the
And it is very, it can be sent to the, who is that court?
Statute says it is
nothing.
Acha.
That's the head of court and
No,
sessions court can
any
take it.
sessions court,
Additional
session
session
judge we
judge.
can send, or
Additional session
additional
judge.
session judge we can send, and the original record is now available with them, because whatever it is coming to us now is the Xerox copy.
Yes.
So the original, there would be no difficulty,
Difficulty.
provided that witness is alive. That is one part is to see.
I'll
because,
take that instruction. PW 14 will only have to testify, Your Lordship.
Right.
Yes.
PW 14,
Only.
you are to make a specific prayer that let that PW 14 be recalled, and to prove this particular document. And you must cite that it should have been marked as an exhibit. It has not been done because of the settled position of law. This is admissible also. So means you can take and file and petition in accordance, and he has of course a right to file the objection to that.
Lordship.
Thereafter we'll decide whether it is to be allowed or not, and if it is allowed, whether we'll record or it will be sent to the concerned trial court. That is the procedure. So you think over it, and we can take up this matter tomorrow. There is no problem.
Lordship.
This is a vital part of evidence, because once this document is marked as exhibit, it will corroborate the bedded ticket entry also. Bedded ticket has been marked an exhibit. Now this will corroborate out, because now the oral evidence of that PW5 is not there, because he has turned hostile. That part is not stating that any such dying declaration was made. And so now you are banking mainly on the evidence of two witnesses, particularly this IO and the doctor.
14 and 1.
Oh, right. So think over it. We can take up this matter tomorrow.
My lordship.
Thank you.
Yes.
Grateful, my lord.
And take instruction to your agency. This person, even if he has retired, he must be taking pension. If he's a leave, or so what is it?
He was 54 by then, maybe 15 years old.
No.
Maybe they are 70. He must be.
Or somebody present, posted at that point of time in the police station, who is accustomed or has about the handwriting of that person. He can just come and say also that this is in the handwriting. That document can be. So there are different.
In
ways
absence of the person
in
who else
absence
can
of the-
prove it.
that part also you take instruction. It's very easy to know that whether he's alive or not, and in which place he must have retired. As it appears, he must have retired in the meantime. But whether where he is
It was
now,
disposed of.
and it is now very easy also. He may not come to the court also.
Yes.
It can be recorded
From his
the
home,
from
nearby
this
court.
nearby court. He is to be produced there. With this virtual court recording made it very easy for the official witnesses to depose. It can be done. It can
Because of
very
old age, he may not come
Ah.
also. He can deposit from his
you
place.
will go to the nearest court, and there the arrangement can be made. It can be recorded. There is no problem in that. All right.
My lordship.
Yes.
I know your lords, how your lordship is pressed along with that election petition, my lord. I only pray that my entry model is going to be expire on 9. It's an appeal, and it should have been listed in face admission list. But anyway, my lord, I pray any day in a supplemental list, the man is 85 years old. It is an appeal wherein, my lord, the sentence was passed, the conviction was made, and item 190. Any day supplementary list next week, convenient to your lordship's board. I don't want to disturb the list, my lord. 190. My lord. Appeal admit ହେଇନି ଆପଣ କହିଥିଲେ ଯେ to move before the writ criminal. In fact, my lord, what has happened in this case, on the date of judgment, the petitioner, who is 85 years old, was traveling from Angul and fell ill, was hospitalized. But however, my lord, judgment was pronounced and without hearing sentence was pronounced. I filed an appeal and challenging that sentence and warrant. I filed an writ petition criminal. Your lordship observed either you surrender or wait for the judgment of writ petition criminal. And in writ criminal, the NBW was stayed till 9th and observing that I must approach the appellate court. That is your lordship's court. So interim order is expiring on 9th. It can be disposed of.
No, you are to surrender before the trial court.
Lordship has given two options to me. Either wait for the result in writ petition.
So now that is over.
In that appeal, in that writ criminal, direction was given to me to appear before your lordship and approach by appropriate.
You see, that is to be pronounced in presence of the sentence.
That observation has been made by your lordship's order and.
So you are to surrender. That is why the NBW has been issued. So if you come to the operative part of the judgment, that is at page last page question 59.
Your lordship directed me.
Just a minute.
Last order of your lordship.
So even in your absence, the sentence was passed.
Again.
Now, if the RI is for 3.5 years, so once 3.5 years means, so you are to go to the jail. Then you are to from the then you can file your bail application. You cannot be. Yes.
I was given two options. Either I have to surrender or wait for the result in writ petition criminal.
Unless you file the surrender certificate, how can you be granted bail? Because you are to be taken into custody since 3.5 years is there. Trial court has no power to grant you bail. So you are to go, and the moment you surrender, produce that surrender certificate. The case is in the list. If you surrender today, tomorrow the matter can be taken off and you can produce the surrender certificate. So there is no problem.
It will be violation of your lordship's order.
What violation?
I was given a direction to approach your lordship by way of a application. I have filed that application. That is my problem.
What application? I have observed that since the appellant has not surrendered before the trial court after pronouncement of the judgment, the appeal will be taken up after his surrender before the trial court or and after he filed the surrender certificate in view of the provision under section so and so or any other order passes. So that part is over.
So in that application, I was directed to appear before your lordship and by filing an appropriate application. So say application da pending was. Say I think.
Where is that application? I am disposing of that application in view of my order. You surrender before the. Where is that application?
Maybe taken up tomorrow even.
No, give that application. You have mentioned at the past. I'll dispose of. Show me that application. What is that application IN number?
Is 1845.
This IN number 1845 of 2023. This is an application filed by the petitioner for suspension of sentence, and that your application which you are moving now.
Lordship may kindly have a glance to that judgment of your lordship's this honorable court.
No, I am dealing with the IN number 1845 for suspension along with the fine and stay of execution of NBW pending disposal of the appeal. When the matter was listed on 3/7/2023, since the appellant had not surrendered before the Land and Trial Court after the pronouncement of the judgment, it was directed that the appeal would be taken up after his surrender before the Land and Trial Court or after he filed the surrender certificate in view of the provision under Section 389 CRPC, or any other order is passed in CRLMP number 1102 of 2023. The Land Council for the petitioner submitted that in the meantime, CRLMP number 1102 of 2023 has already been disposed of, and it has been observed that the petitioner to file an appropriate application before this court and for the purpose of the NBW issued against the petitioner was directed to be kept in abeyance for 2 weeks so as to enable him to obtain the appropriate order from the appellate court.
Has been made that procedure is completely illegal.
Considering the submission made by the Land Council for the respective parties, and after going through the averments taken in the interim application, I don't find any merit in the interim application. The petitioner should comply the order dated 3/7/2023 and produce the surrender certificate, whereafter the appeal will be taken up for admission and for consideration of the interim applications for bail and stay realization of fine. Yes, next.
My lord, item 179, in which report has come, my lord, for the verification of genuineness
Item,
of two
just a
local
minute.
securities.
Yes, which side?
179.
Hmm.
My lord, on the last occasion on 25/9/2023, my lord, lordship directed to submit the for the documents with regard to two local sureties, and that verification has already come, my lord.
Okay, we'll see that. You get that file and see if verification has been made or not. Yes.
Lordship, item 154 I have mentioned that
Yes.
matter may kindly be taken up on the health ground. On interim application is pending.
Okay. You see that what instruction has been obtained. 154. Health ground abhi file kar rahe ho.
No,
No.
Lordship, they have-
It has already been filed. Order has already been passed. So see whether any instruction has come or not. Okay.
Lordship,
Yeah.
item 111 and 80, your lordship. Yesterday I had mentioned your lordship to be taken up first.
Oh, wait.
111 and 112 item.
Yes.
Press appeal matter only to be admitted. Delay is there, your lordship. 107 days.
100?
111 और 112.
आएगा तुम्हारे को.
Both arising out of one judgment, your lordship.
The case of conviction.
Yes, your lordship.
What sentence has been imposed?
10 years and 1 lakh rupees fine, your lordship. Page 40, your lordship.
Okay. You have filed an application for condonation of delay.
Yes, your lordship.
What is
IN
that
number
IN?
2413.
Yes, Mr. Tripathi. It's a case of conviction and there is delay of 100 odd days. IN number 2413 of 2023. This is an application for condonation of delay in filing the criminal appeal. The stamp reporter has pointed out that there is delay of 107 days in filing the criminal appeal. After considering the submission made by the London Council for the respective parties, the averments taken in the interim application, since 10 years of substantive sentence has been imposed on the appellant, I am inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Part admit, call for the trial court record. Interim applications for bail and stay realization of fine to be considered after receipt of the trial court record. Yes, this is
Same.
item number 111.
Yes, your lordship.
Hello? So delay condone, admit. Yes, कौन कहले?
ଆଉ ଗୋଟେ 112
Same
same
judgment.
judgment another recusal also.
Same judgment भाले. Item number next.
My lord, I am submitting from DC court to Noida, my lord.
So there the delay is
107 days, Your Lordship.
107 days. Same, no? So delay condone. Admit, yes.
Obliged.
My lord, I am third, my lord.
My lord, 1 appeal, 7 years, 6 months in custody, my lord. Item 201, my lord. Last provision, my lord, adjourn this matter only for the criminal assistant. For my provision, no criminal assistant they are now.
Item देखो ना.
201.
My lord, item number 142, my lord. The first item, my lord. 142, there are two matters. My lord, I have mentioned yesterday. On the health ground, I have filed one modification.
If you have mentioned, it will be taken up. Wait.
My lord, obliged.
That's the restoration of BLAPL application dismissed for default.
File the memo. Sada list करे दो.
My lord, item number 107 today also, tomorrow also, yesterday mentioned this matter.
ठीक है.
Pardon, item get
Yes.
Interim application for interim bail, my lord. Petition of sister marriage will be held on 24/11, my lord.
File the memo.
There is no person in the.
Pardon, my lord.
Get the list. Memo.
In item 117.
Hmm.
Item 217, there is a delay of 37 days, Lordship.
217.
Lordship. 217.
Wait. What is this criminal appeal for?
Appeal for Lordship imprisonment under section.
Conviction matter though.
Conviction matter, Lordship. Under section.
What is the, how much delay is there in?
37 days delay.
No, it is 40 days. And you have filed a delay condonation appeal.
Lordship.
All right, खाली 40 days कर देवे. बाकी sentence कितने इजी?
Sentence 20 years, Lordship.
20 years, बाकी सब करी delay condone. This is item number 217.
17.
है ना? So delay condone, IA disposed of, admit, and you have filed application for bail and sterilization of
Lordship.
Those are to be considered after receipt of the trial. Yes.
My lord, item number 140. Item number 140, my lord, CRL 260 of 20. Only the verification report was awaited twice.
One item number?
140, my lord.
Item 140, there are two items. What is your number, case number?
CRL 260 of 20, my lord.
Okay, the first one, Raju Kumar Kushwa.
Yes, my lord.
So what do you want?
My lord, your honor had heard it and the verification report was awaited for.
What report?
Since from his village through the SP Noyagar. Report was called for.
The color on report is right. Oh, address verification paintila.
Yes, ma'am.
So you bring that file and see. 140. This is item number 140, but the first item, CRLA number 260 of 2020. So you wait till the Land and State Council is getting that file there, whereafter it will be taken out.
Yes, my lord.
Yeah.
My lord, item number 118, my lord.
Yes.
My lord, 118.
Yes.
My lord, inadvertently, the criminal appeal was written instead of a criminal revision, which was pointed out by the SR.
So you are to file an interim application for change of nomenclature.
No,
you
my
should
lord.
file an IA for change of nomenclature. The stamp reporter has pointed out that CRL REV is maintainable. You have filed CRLA. So once your nomenclature is changed, it is to be re-registered and placed before the appropriate bench. So file
My
that and interim application. Right?
My lord. My lord.
Item number 118 of today's weekly list are Mr. Rabindranath Bari from the Virtual High Court, Noyagarh. He submits that in view of the report of the stamp reporter that against the impugned order, CRL REV is maintainable. He intends to file an interim application for change of nomenclature from CRLA PO to CRL REV. List this matter immediately after the interim application is filed. Yes.
Weekly list, item number 24. Item number 25.
My lordship. Hereby the offense under 341, 323, 294 and 50.
Notice sufficient, Mr. Tripathi?
Yes, 20-10-23.
Three of the.
Wait. What is the custody rate?
Now custody rate 16/6/2023.
16/6/23.
Yes, my lord. He was on bail, my lord.
Charge sheet submitted.
Charge sheet submitted. He was on bail, my lord.
Okay.
And during non-appearance of the present petitioner, NBW issued on 4/3/2023, my lord.
4/3?
No, 4/3/2023.
23,
my lord.
NBW was issued.
Issued and arrested on 16/6/2023.
So it's a Belgium matter.
Yes, Belgium matter.
Where it is mentioned that you are on bail. Okay. Yes, Mr. Tripathi.
Yes, my lord.
Are the London Council for the petitioner London Council for Justice was on bail, taken into non-taking of steps, non-bailable warrant of arrest was issued, taken into custody on 16/6/23. Allowed.
Item number 26.
CD available? Notice has not been issued?
No, my lord.
Race matter?
Yes.
PSC Act is there?
Yes.
Right, since one of the offenses found, so extra copy to be served, notice to be issued. Gote saptah pare mane 20 tarikh rakhi diyantu. You serve the note copy by tomorrow. Yes.
Item number 28.
May it please your lord.
Notice sufficient?
No, no, my lord. Confirmation report not received. Has been
And you have got the case diary?
yes, my lord.
So get the confirmation. I'm taking
Yes.
it on 13th of November. The London Council for the State submitted that though he has received the case diary, but the confirmation letter regarding service of notice on the informant is awaited and the matter may be taken up next week. List this matter on 13th November 2023. Instruction be obtained in the meantime.
Yes.
Item number 31.
Yes.
Yes, Mr. Joshi.
Yes, my lord.
Yeah.
Extra copy was given to the state, to enable for
You
onward
have
communication.
given?
Yes, since long. On 11/9.
Mr. Tripathi,
That also confirmation is not received.
you have received the case diary?
The connected case.
Yes, yes.
Item number 31.
Yes, yes, yes.
Same order कर दियंतु 13 तारिख रे रहइबो. Confirmation letter ଆସିବ regarding service of notice on this one. So yes.
Item number 32.
May it please, my
Mr.
lord, may be allowed to appear virtually, your
Yes,
lordship. Lord, here it's a bail under the Atrocities Act, which the
Notice has been issued. Notice has been issued. Yes, have you served the extra copy, Mr.
Yes,
Das?
Yes, my lord.
Yes,
Item 32 notice served on 14/10/23.
Okay, you have received the case diary also.
Yes, yes, my lord.
Okay, you can argue your case, Mr. Das.
Lordship. Here, my lord, the appellant is in custody since 29/1/2020.
Just a minute, just a minute. What is the
Item number 35.
35, Lordship.
Hmm. Hmm. You have not received the so moto appeal.
Notice was issued.
No,
Notice
issued, but he has
notice
not.
served on 28/10/23.
But he has not received. Serve a copy so that it can be taken up next week. The Okala Tamada. In Handi Tamasati. What bullshit on this? Mr. Suryakant Dwivedi and his associate filed power for the informant Anil Kumar Shetty, which is taken on record. Land counsel for the informant submitted that not received the copy of the appeal memo along with the documents annexed thereto. Let the land counsel for the appellant supply the same to the land counsel for the informant by
Lordship, in between some of the co-accused persons who stands on the
by tomorrow.
same voting was granted bail. I'm giving copy to the State Council, Your Lordship.
The land counsel, have you already given?
I will give.
All right. So hand over to Mr. Tripathi so that it will be sent. The land counsel for the appellant further submit that some of the co-accused persons have already been released on bail, and he will supply the bail order copies to the Land and State Council by tomorrow. Like those, and counsel for the state shall examine the claim of parity put up this matter on 13th of November 2023, indicating the names of the London Council for the informant in the cause list as well as in the top of the brief. Yes.
Item 36.
Item 36, may I please?
Item number 37.
My lord, in item 37.
Number 40.
Mr. Santosh Kumar Mahanti, yes.
39. The allegation of 376 lordship. The
No.
notice has been issued to the victim lordship.
Huh? 39 ta? 39, Mr. He said it was taken off along with item number 28, and the State Council submitted that notice. He has not received the confirmation letter, so it has to come next week, and he has to obtain the confirmation letter. He has obtained the case diary, but his informant's notice confirmation letter is to be obtained by him. Okay.
Okay.
And it is tagged to that item number 28. That is another co-accused, Manoj Kumar Sahu. Or it is the same person, no?
Same person, lordship.
So same person has two cases or one?
My rejection is ordered at 8/8/2020.
No, that is also by Manoj Kumar Sahu.
Lordship. But the only accused in the present case, lordship.
Then why two cases have been filed? Just a minute, let us see that.
The same self another.
Just a minute, let me see. 9, এটা বাহার করলে item number first 28 টা বার করুন। Case number দেখিলে, FIR. This is Purushottompur PS case number 407.
Lordship.
And what about this item? 39. FIR person, FIR. Oh, 407, same case.
Who application by
No, you have filed the subsequent application.
Lordship.
His application is at the first instance. So you withdraw that application. अच्छा से जो item number 28 रे लिखा है ये इतला item number 39 से आसियो से order टा को correction कर देबे 39 टा dispose of ହେଇଗଲା ହେଲା आपण 28 रे बाकी rest of the order रहियो बुझ पाइले आ खाली 39 टा रे लिखंतु आपण since the appellant Manoj Kumar Sahu has filed another bail application that is CRLA number 831 of 2023 in the same which arises out of the same FIR. This London Council for the appellant doesn't want to praise this CRLA. Accordingly, the CRLA is disposed of.
Item number 40.
Yes.
And the present petitioner in custody since 28/7/2023.
Notice sufficient, Mr.
Yes, my lord. 11/10/23.
This is item number 14. And you have obtained also the case diary?
Yes, yes.
Okay. PRLA 933 of 2023. What is the date of custody?
28/7/2023.
28/7/2023. Charge sheet submitted.
294, 323.
Wait. 294.
323.
Yes.
506.
427.
307. 325. And 31R, 31S, 32VA, and 32V of SC/ST.
So who is that injured?
There are 3 injured persons. My lord, Sanjay Naik, Jhunni Naik,
Sanjay Naik.
Sanjay Naik, Jhunni Naik, and Sulochana Dei, alleged Naik. And if the Sanjay Naik is concerned, your lordship.
Sulochana Dei.
Yes.
Sanjay
Naik, simple injury, your lordship. Jhunni Naik, no injury. And Sulochana Dei is also 4 injuries. Out of them, 3 are grievous and 1 is simple. 3 are fracture injuries and 1 is simple.
So what is his statement? The statement of Sulochana, who assaulted him?
This person tried to run over a vehicle on him. Well, I'm reading one of the eyewitness. ମୋ ନାଁ ମନୋଜ ପରିଡ଼ା, so and so. ଜମାନ ମାନେ ଏତିକି ବୋଲେରୋ ଗାଡି ନମ୍ବର ଏତିକି ମୋର ଅଟେ। ମୁଁ କିଶୋର ବେହେରାକୁ ଡ୍ରାଇଭର ଭାବେ ନିଯୁକ୍ତି କରିଥିଲି। କିଶୋର ବେହେରା ଇଜ ଦ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର। ସେଦିନ 11/7/2023 ରାତି 10ଟାରେ ଝିଲି ନାୟକ ତା ସ୍ୱାମୀ ସଞ୍ଜୟ ନାୟକ ଗାଁ ମୁଣ୍ଡରେ ଥିବା ପାଣି ମୋଟର ପାଖରେ ଛିଡା ହୋଇ କଥା ହେଉଥିଲେ। କିଶୋର ବେହେରା ମୋ ପିକଅପ୍ ଗାଡିରେ ତଲେରା ଗାଁକୁ ଯାଉଥିଲୁ। ସଞ୍ଜୟ ନାୟକ ଓ ତା ଝିଲି ନାୟକକୁ ଦେଖି କିଶୋର ବେହେରା ସେଠାରେ ଗାଡି ରଖିଲା ଏବଂ ସେମାନଙ୍କ ପାଖକୁ ଗଲା। ମୁଁ ଗାଡିରେ ବସିଥିଲି। କିଶୋର ପରିଡ଼ାର ସଞ୍ଜୟ ନାୟକ ଏବଂ ତା ସ୍ତ୍ରୀ ଝିଲି ନାୟକକୁ କଣ ପାଇଁ ମଟର ପାଣିକୁ ଛୁଇଁ ବୋଲି ଗାଳିମନ୍ଦ କଲା। ସଞ୍ଜୟ ନାୟକ ମଧ୍ୟ କିଶୋର ବେହେରାକୁ ଗାଳିମନ୍ଦ କଲା। ସେଥିପାଇଁ କିଶୋର ବେହେରା ରାଗରେ ନିଜର ପିକଅପ୍ ଗାଡିକୁ ନେଇ ସଞ୍ଜୟ ନାୟକର ସାଇକେଲ ଗାଡି ଉପରେ ଚଢାଇ ଦେଲା। ମୁଁ ଏବଂ କିଶୋର ବେହେରା କିଛି ସମୟ ପରେ କୁଡିଆବାରି ଗ୍ରାମରୁ ତା ପିକଅପ୍ ଗାଡି ଧରି ଆସିବାରୁ ସଞ୍ଜୟ ନାୟକ ତା ସ୍ତ୍ରୀ ଝିଲି ନାୟକ ଏବଂ ସାହି ଲୋକମାନେ ଯଥା ସୋ ବଡମା ସୁଲୋଚନା ଦେଇ ଗାଡି ଉପରକୁ ଇଟା କାଚ ପଥର ଫୋପାଡ଼ିଲେ ଓ ଠେଙ୍ଗା ଧରି କିଶୋର ବେହେରାକୁ ଗାଡି ଭିତରେ ବାଡେଇଲେ। ଫଳରେ କିଶୋର ବେହେରା ଗାଡିକୁ ବାମ ପଟେ ବୁଲେଇ ନେଇଯିବା ସମୟରେ ଭାରସାମ୍ୟ ହରାଇ ଇଟା ଉପରେ ଚଢିଗଲା। ସେହି ସମୟରେ ପାଖରେ ଠିଆ ହେଇଥିବା ସୁଲୋଚନା ଦେହର ଗାଡି ବାଜିଗଲା। ଏହା ଦେଖି ସଞ୍ଜୟ ନାୟକ, ତା ସ୍ତ୍ରୀ ଝିଲି ନାୟକ, କେଙ୍କଟ ନାୟକ, ରାଜେଶ ନାୟକ ସବୁ ଆସି ଗାଡିକୁ ବାଡେଇବା ସହ କିଶୋର ବେହେରାକୁ ଠେଙ୍ଗାରେ ବାଡେଇଲେ। କିଶୋର ବେହେରାର ହାତକୁ ଠେଙ୍ଗାରେ ବାଡେଇବାରୁ ତାର ହାତ କଟି ଯାଇ ରକ୍ତାକ୍ତ ହୋଇଗଲା। ମୁଁ ସଙ୍ଗେ ସଙ୍ଗେ ତାକୁ ନେଇ ଦଶପଲ୍ଲା ଡାକ୍ତରଖାନାକୁ ନେଇଗଲି। Case counter case, your lordship. We have also filed a counter case, that is annexer 2, your annexer 3 series, your lordship.
Okay. Yes, Mr. Tripathi.
May I read the statement of one injured person, Sanjay Naik?
Yes.
Yeah. 11/7/23 ତାରିଖ ସକାଳ 10ଟାରେ ମୁଁ ଏବଂ ମୋ ସ୍ତ୍ରୀ ଝିଲି ନାୟକ ଗାଁ ମୁଣ୍ଡରେ ଥିବା ପାଣି ମୋଟର ଘର ପାଖରେ ଛିଡା ହୋଇ କଥା ହଉଥିଲୁ। ଏହି ସମୟରେ ଆମ ଗ୍ରାମର କିଶୋର ବେହେରା ପିତା ସୋଆନସୋ ଏବଂ ମନୋଜ ପରିଡ଼ା ପିତା ସୋଆନସୋ ତାର ପିକଅପ୍ ଗାଡିରେ ଆସି ଆମ ପାଖରେ ପହଞ୍ଚି ଆମକୁ ପାଣି ମୋଟର ପାଖରେ ଘର ପାଖରେ ଦେଖି ଗାଡି ରଖିଲା ଏବଂ ପାଖକୁ ଆସି ଅସଭ୍ୟ ଭାଷାରେ ସ୍ଲାଙ୍ଗ ତୁ ଏଠାରେ କାହିଁକି ବସିଛୁ, ସ୍ଲାଙ୍ଗ କହିଲା ଅଛୁଆଁ ପାଣି ଟାଙ୍କିକୁ ଛୁଇଁଲୁ କାହିଁକି କହି ଗାଳିମନ୍ଦ କଲା। ଆମେ ତାକୁ ବିରୋଧ କରିବାରୁ ସେ ମୋତେ ବାଡେଇ ମୋର ହାତ ଭାଙ୍ଗି ଦେଇଛି ଏବଂ ମୋ ସ୍ତ୍ରୀକୁ ମଧ୍ୟ ବାଡେଇଲା। ଗଲାବେଳେ ଧମକ ଦେଇଗଲା
ହାତ ଭାଙ୍ଗି ଦେଇଛୁ,
ଗାଡି ଆକ୍ସିଡେଣ୍ଟ କରି ମାରିଦେବି, କିଏ ରକ୍ଷା କରିବ। ତାପରେ କିଶୋର ବେହେରା ରାଗରେ ନିଜ ପିକଅପ୍ ଗାଡିକୁ ନେଇ ମୋ ବଡମା ଘର ଆଗରେ ଥିବା ମୋ ସାଇକେଲ ଉପରେ ଚଢାଇ ଦେଇ ଭାଙ୍ଗିଦେଲା ଏବଂ କୁଡିଆବାରି ଗ୍ରାମ ଆଡକୁ ପଳେଇଲା। ଆମେ ଏସବୁ ବିଷୟରେ ରାସ୍ତା ଠିଆ ହୋଇ କଥା ହେଉଥିବା ବେଳେ କିଶୋର ବେହେରା ପିକଅପ୍ ଗାଡି ଧରି ଆସି ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ରଖି ବଡମା ସୁଲୋଚନା ଦେଇକୁ ବାଡେଇ ଦେବାରୁ ତାର ଗୋଡ ଖଣ୍ଡିଆ ହୋଇ ସେଠି ବେହୋସ ହୋଇ ପଡିଗଲା। ମୁଁ ଏବଂ ମୋ ସ୍ତ୍ରୀ ଝୁନି ନାୟକ ସଙ୍ଗେ ସଙ୍ଗେ ତାକୁ ଚିକିତ୍ସା ପାଇଁ ଦଶମଲା ମେଡିକାଲକୁ ନେଲୁ। ଏହାପରେ ତା ଦେହ ସଂକଟପନ୍ନ ହେବାରୁ ତାକୁ କଟକ ବଡ ଡାକ୍ତରଖାନାକୁ ନେଇଛୁ।
ଯୋଉ କହୁଛି ହାତ ବାଡି ଭାଙ୍ଗିଦେଲା simple injury
So the injured has been discharged. That lady Sulochana.
well discharged.
And you also lodged one FIR.
Well,
you brought allegation against that Sanjay and Juni.
Sanjay Juni simple Juni ର injury କିଛି ନାହିଁ. Sanjay
In
simple.
your FIR, the Sanjay and Juni has been arraigned as accused.
Well,
so had the Learning Council for the state, Learning Council for the appellant, Learning Council for the state submitted the notice and the informant has been made sufficient on appeals for the informant. Learning Council for the appellant further submitted that the appellant is in judicial custody since 28/7/2023 and he has been charged sheeted under section so and so. It is a case and counter case, and there are 3 injured persons in this case according to the prosecution case, but medical examination report of one Juni Naik indicates that he has sustained no bodily injury, whereas one Sanjay Naik has sustained simple injuries. So far as Sulochana Dei is concerned, she has sustained 3 grievous injury and 1 simple injury. Land Council placed the statement of one Manoj Parida and argued that in view of the nature of accusation against the appellant, the bail application may be favorably considered. Land Council for the state opposed the prayer for bail and placed the statement of injured Sanjay Naik. Considering the submission made by the Learning Council for the respective parties, the surrounding circumstances under which the occurrence allegedly taken place, nature of accusation against the petitioner, the period of detention of the petitioner in judicial custody, and since investigation has been completed and charge sheet has been submitted, I am inclined to release the appellant on bail. He shall appear before the Learning Trial Court on his date. The case should be posted for trial and shall not indulge in any criminal activities or tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail. Bail allowed.
obliged.
Item 41.
May I proceed? The appellant before your lordship in custody since 17/4/2023.
Sufficient, Mr. Tripathi.
Lordship, we are yet to receive the instruction. In fact, last date.
Okay, send that to the concerned police
Lordship.
station. Learning Council for the appellant submitted that in compliance to the order of this court, he has served the extra copy of the criminal appeal memo yesterday on the Land Council for the state. In view of the submission, Land Council for the state shall take steps for service of notice on the informant and produce the case diary and also obtain instruction about the criminal antecedent, if any, against the appellant list this matter in the week commencing from 20th of November 2023.
Okay. Item 43.
43 Milord, it's a 14 SC/ST appeal Milord virtually for bail and last occasion my lord directed my state council to serve notice to the Milord.
Mr. Misro,
Lords, yet to receive the instruction, Your Lordship.
same order that it has already been sent and he is to receive notice. Case diary also you have not received.
Not yet received, my lord.
So 13/10/2023. 13/11 said. 13/11/22.
In a connected matter of the same FIR, Your Lordship, we have made the
Granted
notice
bail.
sufficient. Connected matter, Your Lordship.
Yes.
Not in this matter, though. Their notice has been sufficient.
What is that matter?
Lord, that is
Notice sufficient?
It's a fresh matter, Your Lordship.
Oh, fresh matter. Okay.
302 and 3 SC.
But there is delay. It has been pointed out. What is the delay? Oh, 374 days. Allah. Order has been passed. Look, IN number 2670 of 2023 is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 374 days in filing this criminal appeal. Extra copy to be served, notice to be issued, matter to be listed on 20th of November 2023. CD and CA to be also obtained. Yes.
In the meantime, Milord, the trial has begun. The man is custody since 2015.
Hmm.
And, about 8 years in custody, Milord.
In view of the submission made by the Land Council for the appellant that the appellant has remained in custody for about 8 years and prosecution evidence is not closed. Let a status report.
Item 48.
47 टा कौन लगी?
Sir, item number
Huh?
47, sir.
ଏଇଟା ନାଇଁ ଏଇ ଯୋଉ ତା ପୂର୍ବଟା 46 ଟା. Okay.
47, my lords.
47, sir.
47.
My lord.
40, now the last item called, it was item 46, no?
6, yes.
So now it
47
will
is
be
yet to be called.
47, it should be called now.
No, 47 was called.
Item 47.
No, no, your item is 46.
47, sir.
47.
No. This is CRLA number 996.
My lord,
So it's item number 46.
46.
Oh, sorry, my lord. I
Yes, item number 47.
47, Lordship, yesterday we have made the notice sufficient. Yesterday only. Because the informant was not residing at her given address.
Okay.
She returned yesterday.
All right. Mr. Counsel, notice has been made sufficient on the informant, but it is just yesterday. So I have to give 1 week time so that he may engage any counsel. So I am adjourning the case. It will come on 20th. You have received the case diary?
Yes, Your Lordship.
All right. The learned counsel for the heard Mr. Ajit Prasad Mandal, learned counsel from the virtual High Court, Koraput at Jaipur. The land council for the state submitted that notice on the informant has been made sufficient yesterday in order to enable the informant to engage any counsel to oppose the prayer for bail. Time is allowed till the matter time is allowed. List this matter on 20th of November 2023. Yes.
Item 48.
May I please, Your Lordship? The petitioner is in custody since 16/9/2022. Allegation
Notice sufficient?
No, Your Lordship. None. CD is also not with us.
Already sent.
Yes, we have sent.
Same order, 13/11/2023. It has to come.
Item 49.
You are for the?
I am the applicant.
Okay. You have received the case
No,
diary?
sir.
All right. Feel मारना कौन कि सबू कथा शिखेइबो ना कौन The Land Council, Mr. Ajit Panda and his associates have filed power today in court for the informant which is taken on record. The Land Council for the appellant is present. Mr. Land Council appearing for the state submitted that he is yet to receive the case diary. Which police station, Mr. Misra? So get it will take up on 13th. Place this
Lordship.
matter on 13th of November 2023. CD to be obtained in the meantime.
Instant matter.
D'accord.
Passive item number 13.
इधर बोर्ड रे देखी जो डिस्प्ले बोर्ड रे आइटम नंबर 13 चलला बेली तो अमूल्य रत्न पंडा नाहंदी
And 16 Lordship paper next week.
अर्जुन प्रे फॉर अर्जुन नेक्स्ट
Item 18.
18 Mr. Monranjan Padhi and Tukuna Kumar Mishra. Pinanti. Non appears Arjun.
Item 19.
19 Mr. Das Parida.
Lordship heard this matter yesterday. That matter where co-accused was granted bail, but against this person, 27 Evidence Act was there. On his
कौन है जी?
against this person, my lord, 27 Evidence Act was there.
यार गोटे मु लेखा ही नखला स्लीप फाइल स्लीप में लगी होती काउंटर न लास्ट टू मराई काली किछि मु लेखिथिली
आगे स्लिप टा भी दे
ଦେଇଥିଲେ କୋ ଦିଅ I beg your pardon, my lord. You submitted that he was taken into custody on 8/11/2022. Charge sheet under section 364, 302, 201, 120B, 32B VA. And one skeleton was कौन हला कौन कौन
File that रही जाइए. Mr. Das is ill. He is going to file that matter packet for this. Advertently रही होला court chamber.
No, what is his submission is that one co-accused has been released on bail and is claiming parity, except one difference is that at the instance of this appellant, the skeleton was recovered. The skeleton was actually from that soil from dogged out, and that skeleton was recovered. So it was within his exclusive knowledge. So that is what I pointed out to him, that how you are claiming parity when that material was not
Informant is
there.
also there.
Huh?
Informant is also there.
So how do you claim parity with the other person? Because that evidence is a clinching evidence. There was a river bed inside which in that river bed the skeleton was found.
But I'm going to the
It was
sheet. In the
yeah.
charge sheet, they were said that they were also in doubt that whether the skeleton belongs to the deceased or not. For that, DNA test report was called for.
That was duly identified by the mother, father, and the uncle of him in presence of the Tahsildar, that was Diglot's. It was in a paddy field where
It was lying in open or
no, not open. It was duly taken from the paddy field. On the instruction of this present petitioner, he was the
not from the river bed. I was
no, not river bed, from a paddy field.
Okay, paddy field.
Right, Rods. And he is this person who has killed that lady. That he was in love with that.
So who is that co-accused him whom you say that has been released on?
Two co-accused, in fact, another co-accused also killed by Ponnamali Rao and Damburudhara.
No, there is no such evidence against them relating to this 27.
27 ଜଣଙ୍କ ନାଁ ଥିଲା ଯେ ସେ weapon recovery ଦେଇଛି।
No, weapon recovery and
ନାଇଁ ଆଙ୍କର ନାଁ ତାଙ୍କ ନାଁ ନୁହଁ।
so you stand on a different footing
Yes,
totally.
altogether.
I have also recorded, I think.
Yes, that.
Yes, Learned Counsel for the state submitted that absence of any direct evidence, and since the only material available is the against the appellant is the confessional statement of co-accused.
That is present.
So, but at your instance,
DNA test report DNA test ପାଇଁ ମଗା ଯାଇଥିଲା।
That is not relevant. The body.
You see, the postmortem prior to when the dead body was recovered at your instance, the it appears from a field in the month of November 2022. There are something for which the family members identified the skeleton to be that of the deceased.
By seeing the wearing apparels.
Huh?
By seeing the wearing apparels found on the body.
Yes.
And the skeleton. That the mother, father, and the uncle of the so-called deceased, they identified the body. I mean, the skeleton that belongs to that lady.
That's a different matter. What would be the DNA test? So
it's a matter of trial.
You move after some witnesses, particularly the witness to this leading to discovery is examined. Are the Learned Counsel for the petitioner, appellant Learned Counsel for the state, and Learned Counsel for the informant. Though the Learned Counsel for the appellant claim parity with co-accused Damburudhar alias Kanhu Rao, who has been directed to be released on bail by this court in CRL number 643 of 2023 as per order dated 31/7/2023. But the Learned Counsel for the state as well as Learned Counsel for the informant submitted that at the instance of the petitioner, a skeleton was recovered from inside the paddy field, na?
Paddy field.
Paddy field. And therefore, and those such material was not there for the co-accused who has been directed to be released on bail. Therefore, he cannot, the appellant cannot claim parity. Considering the submission made by the Learned Counsel for the respective parties, even though there is no direct evidence available against the appellant, but the nature of circumstantial evidence on record, and since the petitioner is not similarly situated, appellant is not similarly situated, like the co-accused Damburudhar alias Kanhu Rao, I am not inclined to release him on bail. However, taking into account the period of detention of the petitioner in judicial custody, I direct the Learned Trial Court to expedite the framing of the charge and examine the witnesses to the leading to discovery. The petitioner is at liberty to renew the prayer for bail of the leading to discovery of the skeleton of the deceased. The petitioner is at liberty to renew the prayer for bail after examination of such witness disposed of.
Pardon my lordship, item 18.
कितना नंबर गला जी?
Not placed.
Yes.
Pardon my lordship, item 18. 391 of 23 not present.
391 of 23.
Yes, my
It
lord.
has already been adjourned yesterday. So you keep it on record. এটা দেখি দেবে হ্যাঁ ଆଜି ଆଜି ହେଇଥିଲା ଓ then you just not press it ମୁଁ କହୁଛି କାଲି ହେଇଥିଲା ଠିକ ଅଛି not pressed
Lordship,
Mem-
CRL 20 55 of 21
ହଁ
ସେଥିରେ ଆମେ appear କରିବୁ wakalat.
will appear for the whom the appellant
Yes, my lord.
you filed the wakalatnama
Yes, my lord.
with the consent of the earlier counsel Mr. Misra देखी এটা ছাড় দিন মতে 55 ର ଦିଅନ୍ତୁ not press memo ତ ଫାଇଲ କଲେ ନା ତାପରେ ଏଇଟା 55 ଟା ଦିଅନ୍ତୁ right second item that देखो CRL number 55 of 2021 Mr. Monunjan Padi Land Council files the wakalatnama for the appellant which is taken on record. The name of the newly engaged counsel be reflected in the cause list henceforth in place of the earlier engaged counsel. Yes, letter of authority शामिल कर दिया.
Item 22.
Yes.
Last occasion, yesterday lordship directed to produce the certificate. Yesterday lordship produced the certificate copy. I have submitted my lord.
Certified copy of
Depositions, my lord. 8, 9, 10, my lord.
have you given to the
My
state
lord.
council?
Yes.
Mr. Tripathi is to argue.
Yes, 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 yes,
You have received the deposition copy.
yes, yes.
Any noting was made yesterday in this case? No. Nimai Pradhan. Yes, what is the date of custody?
My lord, 9/11/2022, my lord.
Charge sheet submitted under section.
Cases under section 147, 148, 341.
Go slowly.
147.
Yes, 341 for it.
323. 325. 326. 307. 302. 149 and 3 assisted.
3 SCST कौन? What are the offenses under 3 SCST?
Yes, Mr.
Tripathi.
Charge sheet copy is not available to me.
You have got the charge sheet copy.
3 SCST and 3 SCST and PO Act. Only 3 SCST.
अरे 3, 1, 2 एगुड़ा किसी लिखा ही नहीं खाली 3 लिखा ही जी.
Rejection order सेतिकी लिखा है 3 SCST.
खाली 3.
Notice sufficient ना?
Yes, my lord. 22/8/23.
So who is the deceased?
Kastu Sethi. Kastu Sethi.
KASTU.
My lord.
Kastu Sethi.
My lord.
And somebody must be the injured. What is the name of the injured?
It is the case of 1999, my lord.
This is a split up case, my lord.
Split up case, my lord. Out of 18, my lord, 19 accused, my lord, 18 has been acquitted, my lord. When they have been acquitted,
You are an absconder for this year.
my lord, not absconder, my lord. When they have been acquitted, my lord, 18 accused person acquitted, the present petition has filed one CRLNC before this honorable court, my lord. The case has been stayed for the 8/2/2018, my lord. Final disposal, my lord.
What is that case number?
My lord, CRLMC number 2754.
CRLMC
number 2754 of 2006, my lord. They have been acquitted on 2002, 18/4/2002.
तापरे कौन हला से you CRLMC
they dispose of, my lord.
केबे
8/2/2018
तापरे आउ 4 वर्ष कौन कले 4.5 वर्ष
they asked for the matter. Then he has been arrested in 9/11/2022.
okay, so what is the evidence that has
My
been
lord,
adduced in
my
that
lord,
case?
my lord, thereafter, my lord, he faced the trial. Out of 18 charge sheeted witnesses, 10 have been examined, my lord.
In your case?
My lord.
18
out of 18, 10 have been examined. And eyewitness is 1, 3, 4. They have been hostile, my lord. And PW6 is the informant.
No. You have given the deposition
My
copy
lord.
at Annexure 3
Yes,
series.
my lord.
Okay.
7 পর্যন্ত দেখলি তারপর তো দিল্লি 8, 9, 10
हाँ तो की आपण विरुद्धरे कहिजनी कोन
केही कहिनाहाନ୍ତି
ए
ସେମିତି
पर्यंत केही कहिनाहाନ୍ତି
ନା
Mr. Tripathi,
Yes, my lord.
you have received the deposition copies of how many witnesses?
10.
All the 10 witnesses.
Yes.
So you have verified it. Anybody has stated anything against the appellant?
W.
At 3, 6, 7 as a hostile. Eyewitness 1, 3, 4. They did not say anything. PW6 is the informant. He also didn't say anything.
No, my lord.
Or the learned counsel for the appellant, learned counsel for the state. Learned counsel for the state submitted notice on the informant has been made sufficient non-appears for the informant. Learned counsel for the appellant submitted that the appellant is in judicial custody since 9/11/2022. He has been charge sheeted under sections 1 and so. And out of 19 accused persons charge sheeted, 18 have faced trial and they have been acquitted since 2002. The appellant filed a petition under section 482 CRPC for quashing the proceeding against him in view of such acquittal order, which was registered as CRLMC number 2758 of 2006. And the proceeding was stayed against the appellant. However, the case was disposed of on 8/2/2018. And after the petitioner was taken into judicial custody, out of 18 charge sheet witnesses, 10 witnesses have already been examined, including some eyewitnesses, but they have stated nothing against the appellant. And therefore, the bail application may be favorably considered. Learned counsel for the state, after going through the evidence copy of the 10 witnesses examined so far in the trial court, fairly submitted that they have not stated anything against the appellant. However, objected the prayer for bail mainly on the ground that even after disposal of the CRLMC on 8/2/2018, the appellant didn't surrender till 9/1/2022. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the nature of evidence adduced so far in the trial court, I am inclined to release the petitioner on bail subject to condition that he shall appear before the London trial court local surety karibe. On each date, the case would be posted for trial. and violation of any terms and condition, parental cancellation of bail allowed.
What's your place, man?
Item number 26.
I am pleased, Lord.
Yes.
When the appellant is in custody since 14/6/2023, my lord.
Mr.
Yes, my lord.
Notice
Notice
sufficient?
sufficient. 29/10/23.
ଚଳିବ ସପ୍ତାହ ହେଇଗଲାଣି so 26 CRLA. You have received the case